Have you informed?
Yes.
Okay. The learned counsel has also taken consent from the other side. As prayed, as prayed for, comma, this list is matter after
2 weeks, ma'am.
2 weeks. Okay.
Obligation.
Yes.
May I, Your Lordship? Your Lordship, I beg to mention item number 7. This is a civil revision petition, Your Lordship. And this mention is on behalf of Ketama. Your Lordship, since Ketama is out of station, matter may be adjourned for today and fixed after 2 weeks. And we have also taken consent from the other party.
Okay, Mr.
J.
K.
J. Sring.
J.
Sring. I am on behalf of Ketama.
Okay, appearing on behalf of learned counsel for appearing on behalf of Mr. K. Tama, learned counsel for the petitioner, with the consent of the other side, prays for listing this matter after 2 weeks. 2 weeks. The prayer is allowed. List this matter.
My lord, interim order is there, my lord. Interim
You are
order.
here?
I am for the petitioner.
You are for?
Petitioner.
You are for?
Respondent.
Okay. K. Tama for learned counsel for the respondent. Stop. And Mr.
T. Kamchi.
Learned counsel for the petitioner is also present.
Yes, sir.
Okay. Para. After list is matter after 2 weeks, then the interim order passed earlier shall continue till the next date. Okay.
Much lord.
Your Lordship, I also beg to mention item number 22 on behalf of Ketama. And this is, we have for the petitioner, Your Lordship. Matter may be fixed after 2 weeks.
So have you informed the other side?
Yes, Your Lordship, we have informed to the other party.
Okay. Mr.
J. Sring. Sring.
J. Sring,
On behalf of Ketama.
appearing on behalf of Mr. K. Tama, learned counsel for the petitioner, with the consent of the other side, prays for
2 weeks after 2 weeks.
listing this matter after 2 weeks.
And there is an interim order also that may
The
be
prayer
continued.
is allowed. List this matter after 2 weeks. Stop. The interim order passed earlier shall continue till the next date. Okay.
Obliged, Your Lordship.
May it please your lordship.
Yes.
Lordship, I beg to mention item number 5. Lordship, I am for the respondent. Conducting counsel for the respondent, Ms. Vitamuk is out of station today, Lordship, due to personal difficulties. So kindly this matter may be taken up after summer break. Lordship.
Then who is for the petitioner? Have you informed the petitioner?
Yes, Lordship.
Okay. Your Miss E. Parme, learned counsel for the petitioner is present. Mr.
D. Lona.
D.
Lona.
Lona,
Yes, Lordship.
learned counsel for the respondent. Respondent number?
Sole respondent, Lordship.
Okay. Learned counsel for the respondent. Prays for the submits his senior has some difficulties today, and prays for listing this matter after the
Summer break. Summer break.
Is prayed for by the learned counsel for the parties. List this matter after summer vacation. Okay.
And Lordship,
After
item
ending
number
summer vacation.
item number 21 also, Lordship.
21 also.
Yes, Lordship. I have already informed the respondent.
Here you are for?
I am for the appellant, Lordship. This
Okay.
matter may be taken up after Lordship summer break, Lordship.
Okay. Mr. D. Lona, learned counsel for the appellant, with the consent of the learned counsel for the other side, prays for listing this matter after
Summer break.
summer break. Okay, vacation, Stop. The prayer is allowed. List this matter after summer vacation.
Deeply obliged.
May I, Lordship?
Yes.
I would like to mention item number 20, Lordship.
Item
20, Lordship.
20.
Yes, on behalf of STI, Lordship. And Lordship, taken the consent from other side, Lordship. Lordship, this matter may be after summer break, Lordship.
You are for the
I am,
appellant.
no, Lordship, I am for respondent, Lordship.
Respondent number?
Respondent, Lordship, sole respondent.
Okay. Mr.
Mr. G. Bam on behalf of STI, Lordship.
G.
Bam
Bang.
on behalf
Appearing
of
on behalf of Mr.
STI.
S. Learned counsel for the respondent, with the consent of the learned counsel for the appellant. praised for listing this matter
After vacation also.
after summer vacation. The prayer is allowed, list this matter after the summer vacation. Okay.
Much obliged.
Your Lordship, I beg to mention CRP number 2324. Lordship. It was supposed to be listed along with the item number 19, yes, but not listing
It
listed.
is
yes.
connected matter.
Yes, it's connected matter. Usually it's IA file in the CRP 23. Main case is not listed, so I may be allowed to heard together today itself. Along with the
today,
yes, along
Today
with the
itself.
item number 19, Lordship.
19.
Yes.
Okay. So if it earlier, whether this was any order passed to list along with this,
No,
this is, what is this?
this is the
What-
IA for delay condonation.
IA.
Yes.
Here in this 19.
Yes, 19, item number 19.
Okay, okay, give.
Oblige. Oblige.
Okay.
I'd like to mention item number 4, Your Honor. In this case, I've been informed by the appointed PP here in G. Tado.
Hmm?
Sir, G. Tado, sir, he has informed me, the PP for this case, Your Honor, that his car has been punctured on the way to the court and he will not be able to appear.
For the state.
No, Your Honor, I'm appearing on behalf of Mr. M. Pertin, but he has informed me, the PP for the state has informed me that he won't be
Okay.
able to be present today.
But then see if there is, in the appeal is maintainable here. This is appeal under 374,
Yes, Your Honor.
but the punishment is, what is the punishment here? Around 3 years.
374 is 20 years.
No, the
10 years.
punishment, what we have challenged, the order, impugn order. You are challenging the order where you have been convicted for 3 years, 8 years.
Yes, Your Honor.
So see if the appeal is maintainable under 374. You have filed under 374 too. See it, okay. Miss, you are Miss?
T.Y. Bhutia.
Hmm?
T.Y. Bhutia. It may not be there in the cause list. Your
T-
Honor,
huh?
because my name might not be there in the cause list
It's
because
not
it's an
there.
old matter.
Appearing on behalf of Mr.
M.
M.
Pertin.
Patil, Learned Counsel for the appellant. Submits that the PP is also absent today and prays for listing this matter
After 1 week, Your Honor.
after a week. Okay. The prayer is allowed, list this matter after a week. Okay,
Deeply obliged.
yes.
Well, this two item,
Yes,
any notice may be issued, and this may be tagged up with bail application number 558/2024.
take up along with
Bail application number 5/24.
where it is. Listed.
This code only, before
It is
this.
listed
code.
today.
No, it is not listed today. 19th, it is the bail application number 58 was in notice was already issued on the basis of the same FIR, and it will be listed again on 19th. CD was called on 19th.
Okay.
It's called for 19.
Hmm.
So these two bail applications, item 1 and 2, they are born out of the same FIR
Okay.
and same set of facts.
Or it will be listed on the same.
Listed on the same day on 19.
That is fixed on 19.
19. Milord.
Okay.
Your Lordship,
Yes.
that apart, Your Lordship, since the notice has to go, Your Lordship,
Yeah.
that may be issued.
Okay.
A notice may be issued.
Because if that is so, only 2 days for notice is to be served. Only there is only 2 days.
Ask
for
Mr.
notice.
P.T. Tara, P.T. Tara, Learned Counsel for the petitioner. From Para. This is an application under section 439 of the Code of Criminal Procedure, 1973, praying for release of accused Sri E. Bagra on bail, who has been arrested in connection with WPS case number 20/2024 under section 373 IPC, read with section 6, 8, 12 of POCSO Act 2012 and section 3, 4, 5, and 6 of Immoral Trafficking Act 1956. Stop, huh? Issue notice. Since Ms. Jenny Lanet, ADP, additional PP, has already received a notice
For respondent number 1, Your
for
Lordship.
respondent number 1, no formal notice need be issued to the said respondent. However,
Two, my lord,
the petitioner shall take steps upon the respondent number 2. So how do we start?
usual course, my lord, both will take both.
Okay,
Through police.
Not usual course, if that is so, because it's only 2 days. If Your Lordship
2
may
days,
issue
usual course.
notice
Will it be possible?
through the concerned police,
The
could-
same respondent,
Same matter,
same
okay.
respondent.
Okay,
however, Your Lordship, that the applicants are different. Therefore, if Your Lordship issues notice, for the much convenient for them, Your Lordship, if Your Lordship issue notice through the jurisdictional police station, that would be convenient, Your Lordship.
That's fine. No issue.
No usual,
No, no.
By
usual
register
process,
post-
it will take.
by
couple of
register
days.
post with any then. Okay. Within today,
2 days from today.
okay, 2 days from today, stop. Is prayed for by the land council for the petitioner. So the land council for the petitioner, Father Samit said, the similar. What is the number of that case? These to
54.
be listed along with the other on 19.
Yes, yes. 58.
The land council for the petitioner, Father Samit said, PA number 58,
58.
2024.
4.
Arising out of the same PS case has been already fixed on 19. This matter may also be listed along with the.
Your Lordship, if I may, Your Lordship, if Your Lordship has given 2 days for service of the notice,
No,
Your
we
Lordship.
take steps today.
Thereafter, that's why I was, my suggestion was that Your Lordship, if Your Lordship issue notice through the jurisdictional police station, by afternoon, they'll be getting the receipt from the
Correct.
registry, Your
Correct.
Lordship. If that is to
Okay,
be,
then,
My lord, is correct.
okay, then, so that service upon will be corrected, huh? That the petitioner shall take steps upon the respondent number 2 through the
office of the PP, Your Lordship.
from
Office of the
Through the
Public
Procedural.
Prosecutor.
office of the PP
To the jurisdictional police station.
to the jurisdictional police station. Okay, okay, in the last then, huh? Is prayed, comma. Is prayed for, comma, list this matter on 19 along with
Bail application number
the bail
54.
application number
54 stroke
54,
24.
2024. Okay. Then in this case.
CD may also be
CD
produced on this
also,
day.
huh? Then in the second, is CD, in other case also CD has
Yes.
also been called for.
Yes, because it's only with regard to the
Scan or the.
original
CD.
copy, Your Lordship.
My lord,
Okay, call
original
for
copy
CD,
we
call
have
for
given.
CD, huh? Yeah. Okay.
The blue.
Same order. Same order.
Same order.
Same order. Party name is different.
Party different.
Well, this is a classic case of double jeopardy. For the reasons that, my lord, the private respondent had lodged a complaint against the applicant before the ADM comes here. Yes. ADM comes here, and thereafter, he takes the cognizance of the case, and again, after he becoming the deputy commissioner, my lord, he has filed a complaint against the applicant, my lord. It's a very, something, my lord, unthinkable as to how the power has been exercised in a very indiscriminate manner, my lord. My lord, kindly come. I'll demonstrate from my pleadings, my lord. Page 22 onwards, my lord. My lord, this is my land allotment, my lord.
Yeah.
Thus, my lord, kindly come to page 24 for a moment, my lord. Here, my lord, kindly see this approach rod. ES sector, my lord. That box
It
portion,
says that you have covered more than the allotted area.
they said ki 4 meter,
Yes.
4 meter. And
Yours is 34 square meter.
34 square
So
meters.
they say that if you had to maintain 4 meters distance from the
Huh.
government, but then you have not
In
maintained.
terms of those previous notifications, but that 4 meter distance notification has also been kept in abeyance by the
Okay,
government.
now, okay.
Now,
But then your allotment is
34 square meter.
34 only.
And I'm
So you have
constructing,
exceeded more than 34,
I'm not exceeding it.
not exceeded.
No, not exceeding.
Okay,
Only that
Hmm.
Neelam Lale
Hmm.
is the one who has lost the complaint.
No,
first.
case, what is the status of the case in the trial court?
Try not.
Whether the charge
up-
has been framed?
No, there are two things.
Hmm.
Parallel proceedings are going on. One under section
The
12.
parallel proceeding, it is appeal only. Appeal
Appeal.
is pending.
Yeah, appeal before the deputy commissioner is pending.
Hmm.
Now, the complainant was the deputy commissioner. He is no more there in the ICR.
Yes,
He is posted to Dapur region.
right.
He was the ADM cum CEO, my lord, who
Yes.
passed the impugn order.
Hmm.
Against that, now under section 12 proceedings, there is a stay order.
Hmm.
But after he assumed the office
Hmm.
as a deputy commissioner,
Hmm.
against the petitioner, he lodges a complaint before the police station on the same set of facts.
That probably, the complaint probably, in the charge sheet made clear, I think.
Yeah, well, that's why I'm going to demonstrate that.
Okay,
I thought.
Okay.
Well, that's why I was going through. Milord, kindly
Right.
come to page 25. That is
Hmm.
my land allotment.
Hmm.
This is the passbook which has been given to me, Milord.
Yes, yes.
Just to show it, Milord.
Hmm.
Now, Milord, at page 32, I was asked to give a reply by the chief state officer. Accordingly, I have furnished my reply on 11/8/2020 at page 32, Milord.
Yes.
Milord, for a moment, Milord, kindly see. 3 will be important, Milord.
Page 32.
32, serial number 3, Milord.
Yes.
At the same time, we discussed the matter for amicable solution. His main complaint was against erection of pillar near approach road, as road became very narrow. After my repeated approach, he was not ready to accept. Ultimately, I withdrawn the said pillar on the condition that I should allow to construct a staircase foundation beyond my last pillar, as withdrawn pillar's main purpose was alignment for staircase. He accepted the condition. So this was settled. So we have said ki Neelam Lale, who was the complainant, was having some problem with me. Then accordingly, we had settled the matter amicably.
He is the one who is occupying the government
Quarter.
quarter.
Correct.
Okay.
Neelam Lale is the one.
Okay.
I have made no encroachment. Milord. Kindly come, Milord. This now page 34 is the
Is he the new incumbent or earlier, since he has been possessing or in the said quarter since?
that Neelam Lale is the one
Okay.
who is the occupant of that quarter.
Okay.
Still now he is in occupation. Now, Milord, then what happened after this? Again, the CEO passes this order, Milord.
CEO means?
Chief State Officer.
Hmm?
Chief State Officer.
Okay, chief is.
Yes.
Okay.
Milord. Complaint was received on so and so. Ophthalmic assistant PSC Chimpu against Takot Tagu for illegal encroachment of his allotted government residential quarter at number so and so. In pursuant to the complaint, the matter was taken up under provisions of Arunachal Pradesh Public Premises Eviction of Unauthorized Act 2003 and heard on 15/8/2020 at 1100 hours. Well, this is for one reasons I have referred to. The actual proceedings under is the Public Premises Act 2003. Now, Lordship has seen that I have not occupied the land. Now we can skip this, my lord.
Hmm.
At page 36, my lord. Again, he passes this order. Then against this, my lord, at page 38, my lord.
Hmm.
We have filed appeal under section 12 of the Arunachal Pradesh Public Premises Eviction of Unauthorized Occupation Act 2003 against order dated 18/11/2020 passed by the Chief State Officer, my lord, against this. Now, what had happened? Since he was sitting, so cognizance was not taken. Our appeal was not admitted by the appellate authority.
Okay.
Then, my lord, we prefer this.
Appeal is still pending.
No, my lord. Then what had happened is, then we approach before this honorable court. Kindly come to page 47, my lord.
Yes.
Oh, I was the counsel here. I was the counsel here. Also. Page 48 is it was disposed of at the motion stage itself. But paragraph 2 is important to read for a moment. This writ petition is directed against the order dated 18/11/2020 passed by the Chief State Officer, Itanagar Capital Complex in case number so and so, purportedly under the provisions of the Arunachal Pradesh Public Premises Eviction of Unauthorized Occupant Act 2003, whereby the petitioner has been held to be not maintaining the distance of 4 meters from the government quarter while constructing his residential building on an allotment given by him by the Deputy Commissioner, Capital Complex. According to the petitioner, the necessity for filing of this writ petition has arisen due to the Deputy Commissioner, Capital Complex, not taking cognizance of the appeal filed by the petitioner under Section 12 of the Arunachal Pradesh Public Premises Eviction of Unauthorized Occupant Act 2003 on 19/11/2020 against the order passed by Chief State Officer, Capital Complex, dated 18/11/2020. The receipt of which was duly acknowledged by the Deputy Commissioner. Now, may not kindly come to this next page, second last paragraph. In view thereof, in view thereof, the writ petition is disposed of at the motion stage itself with directions to the Deputy Commissioner, Capital Complex, Itanagar, to take cognizance of the appeal filed by petitioner on 19/11/2020 against the order dated 18/11/2020 passed by Chief State Officer, Itanagar Capital Complex in case number so and so, and enter adjudication on 10/12/2020, on which date the petitioner shall appear before the Deputy Commissioner, Capital Complex, Itanagar, either in person or through his authorized representative. Now, till 10 December, the impugn order passed by the Chief State Officer come ADM was suspended by this honorable court. Now, thereafter, my lord, what had happened was our appeal under Section 12 was taken up by the Deputy Commissioner. And till then, my lord, kindly come to last paragraph, second last paragraph. 1, 2, 3, 4, 5, 6, 7, 7 line. Meanwhile,
Which one?
page 50, my lord.
Page 50, yes.
Page 50 is like third paragraph, second 7th line. Meanwhile, the ADM comes here, Itanagar may keep the eviction at events stay for a period of 3 weeks. My lord. Now, after this gentleman passes, after this Deputy Commissioner passes the order, thereafter no proceeding has taken place yet, my lord. Now, my lord, that 4-meter distance is clarified at page 51, my lord.
Yes.
My lord, if it is not legible, then my lord can kindly come to page 52.
Okay.
Type copy. To all deputy start September 2013, my lord. All Deputy Commissioner, Additional Deputy Commissioner. Supersession of Government Executive Order number LM so and so matters related therein. Sir, it is to clarify that the government of Arunachal Pradesh has enacted that Arunachal Pradesh Land Settlement and Records Act 2000, and it has come into force wide notification number dated 1st day of September 2008. And at the same time, the Arunachal Pradesh Land Settlement and Records Rules 2012 have been notified with extraordinary official gazette dated 3rd December 2012, a copy enclosed. Further, it is clarified that any executive order issued before 1st September 2008 stands repealed under Section 100 of Arunachal Pradesh Land Settlement and Records Act 2000. It is also informed that any executive order issued for maintaining 4 meters setback area from government quarter shall also automatically stand superseded. Now, my lord, what had happened? The basic allegation against me and the proceeding conducted by the chief state officer come ADM was for purportedly encroachment of 4 meters. But I said, I have not encroached it. Now by this order, it is clear. So prima facie, there is no case against me, my lord. There cannot be any proceeding against me under the 2003 Act, my lord. Now comes page 53, my lord. Even that particular 4-meter dispute was already resolved here by means of this agreement between the complainant Neelam Nail and by me, my lord. My type copy is at page 54, my lord. I, so and so, presently residing at ES Sector Itanagar, solemnly declared that I will never complain or complain to authority against Titagu so and so, presently residing at ESS Sector, who constructed a RCC building near quarter number 18 in near future and will not complain for encroachment. Because by this, the complainant also came to know that there is an standing order. There is no encroachment within the periphery of 4 meters of that quarter. So therefore, this was agreement was executed and they have settled. Now, my lord, kindly come. This is second lien or second prosecution against me on the same set of facts, my lord. But the section is different, my lord. Kindly come, my lord. Page 55. FIR against illegal encroacher. With reference to above subject, it is to inform you that one Takotagu ESS Sector Itanagar has encroached upon, demolished the government quarter, public premises located at ESS Sector Itanagar, so and so. Therefore, it is requested to register a case against the Takotagu ESS Sector Itanagar and take appropriate action under relevant section of law, please. Now, my lord, simple no-brainer, my lord. The simple question comes. When the person who was in occupation of that government quarter says that I will never lodge any complaint, how come this has come into, my lord? You cannot blow hot and cold to abuse the process of the law.
This is by DC.
This is by DC. Therefore, my lord, we have by name, we have made him the respondent, my lord, here. Now, my lord, thereafter what had happened, charge sheet was filed, my lord. And this particular section was
With the PDPP Act also.
PDP Act was registered.
Hmm.
This kind of act is deprecable, my lord.
No, he has filed this in the capacity of Deputy Commissioner.
Deputy Commissioner, yes, my lord.
Yes.
Now, because in the earlier proceeding, my lord, he could not succeed against me under 2003 Act. Now he has recourse to another law, my lord. PDP Act, my lord. Can that be permissible on the same set of facts?
No,
And
if,
now-
if this PDPP Act attract, then probably the criminal case or criminal FIR can be lodged. PDP, but it's another matter if you have not encroached. Then the investigation,
Now-
the findings then?
Yeah. Now a charge sheet was filed, then my younger says the alleged accused was exonerated from the PDP Act at the
Okay.
time of filing charge sheet. Come in, please.
Then probably.
Page 64.
Then probably 447 would be problem.
Yes.
447 would be problem. If the PDPP Act goes,
Yes, your lord.
then 447 laws by the DC may not survive.
Correct, my lord. I have described in my prayer, my lord.
In light of this, that notification.
Right.
Yeah.
Your lordship, but for that, your lordship we have to see the records, whether it
Right,
is still in this subsistence or not, that order,
Mm.
whether there is any further modification or not. That has to be looked into.
Well,
Otherwise, your lord-
stay the proceedings, call for the records.
No, the charge sheet already filed.
yes, your lordship.
And the stay probably, it will be difficult for you rather. Because charge sheet already filed, and then since 447 may not lie, and the land trial court also would not like to proceed, because automatically in the CC stage, consideration
What is this?
charge stage itself will be discharged.
They can raise this issue before the
Yes, sir.
trial court. Yes,
You can charge for, you can file for the discharge petition
Yes.
before the trial court.
Well,
That would be better.
Well, the poor fellow stays 300 kilometers.
If we stay, then it will remain probably, because record has to be called and then it will.
No,
in the
High
discharge.
High Court, he will have no problem because prima facie, I have demonstrated my case
Hmm.
and it will be quasi set aside from here on. I need not to appear. Because there is always a predicament of any true gentleman who is wrongly implicated in a case to stand in the docks of a trial court below. For what reasons, why? Well, these are the situations. Even my brother would also not like to stand in the docks. Unnecessarily, a person is being prosecuted. This is complete malice in law, my lord. But stay for the timing and let it be listed on token when 18.
Notice has to go because the complainant informant has
When
been.
the proceeding stay and notice.
Mr. It is the line counsel for the petitioner. I have also heard Mr. at the line additional PP for the state of Arunachal Pradesh. Para. This is an application under section 482 of the CRPC 1973. Praying for passing of the charge sheet number 329/2023 dated 2/12/2023 under section 447 IPC arising out of Itanagar PS case FIR number 190/2023 dated 23/8/2023 under section 447 IPC read with section 3 of PDPP Act dated 30/08/2023 presently pending before the before the court of the Chief Judicial Magistrate, Capital Complex, UPR. Stop. Para.
SGR
To
case,
notice,
SGR case number.
returnable by 4 weeks. Call for the will be the original or the scan copy.
Maybe scan copy, your lordship.
Okay, call for the scan copy of the LCR. Since Mr. Ete accept notice on behalf of the respondent number 1, no formal notice need be issued to the said respondent. However, the petitioner should take steps upon the because this is in the capacity of deputy commissioner only. Could have you see
Your lordship, in personal capacity, your lordship.
personnel.
Yes, your
Because he has lost the FIR.
FIR,
ID.
any person can file an FIR, your
Okay.
lordship.
They take steps upon the respondent number 2 by a registered post with AD as well as usual process within a week from today. So list this matter after 4 weeks. Para. In the interim, till the returnable date, the proceeding of the what is the number, the case number in the
Case number GR number
664.
664.
GR number?
664/23.
Is it in the coast that? Oh, yes. Okay. Pending before the, okay. The proceeding of the case being case GR number 664/2023, right? 23 before the court of Chief Judicial Magistrate, Capital Complex shall remain stayed. Okay.
Grateful, Milord.
Oblige, your lordship.
I think. Okay.
Six.
Yes.
Your Lordship, the dispute is regarding method between the parties. My lord.
Regarding?
Mithun, my lord.
Mithun
Oh.
dispute.
Yes, my lord. So, my lord, apparently the Mithun of the respondent that has identical earmarks with my Mithun, my lord. That was the main issue. So, my lord, as the petitioner, I learned that my Mithun has
Just a minute, what is the stage, an affidavit, an opposition, affidavit opposition file? It's a sole respondent,
yes, my lord.
okay. So,
My lord, there has
how this is civil revision, Lord said? Civil revision,
Civil revision.
okay, you said Mithun,
yes, my lord. I am assailing the order of the deputy commissioner that is in Annexure 7, my
Okay.
lord. Annexure 7, my lord.
just a minute.
Page number 36.
You're challenging the, order,
Order of this deputy commissioner, my lord.
page,
36, my lord. Annexure
36.
7.
Hmm.
My lord, regarding the ownership of the Mithun, there was series of village level Kava conducted wherein the Kava held that the actual owner of the Mithun was the respondent. So, my lord, I during one
you have actual owner,
yes,
actual owner, according
Of
to the
the
Kaba
disputed-
decision, is the respondent is the actual owner.
yes, my lord, of the disputed.
Okay, you are agree by that.
Yes, my lord, I'm agreed
Okay.
by that.
So who lodged complaint before the Kaba?
My lord, there are series of Kava, some complain I lodge and some one person Sri Duyata, my lord. So my lord, this person is this Duyata is someone who has exchanged the disputed Mithun with the respondent, my lord. My lord,
The present petitioner
yes, my lord.
exchanged.
No, my lord, present respondent has exchanged the Mithun, disputed Mithun, when it was in the dispute, my lord. He has exchanged the Mithun with one Duyata, my lord. So, my lord, I file complaint before the police also, my lord, against Duyata and also the respondent. So, my lord, the first cover, my lord. Each at, my lord, page number 21, my lord. My lord, page number 21. This is a translated copy, my lord. This cover was conducted on the basis of the complaint.
This is page 21 is Kaba decision.
Yes, my
Let
lord.
us see your complaint first.
My complaint is,
This decision is result of which complaint?
my complaint is that
Which is the first complaint? Let us begin with the,
Annexure 3, my lord.
hmm?
Annexure 2, my lord.
So to page
Number 16, my lord.
16.
Yes, my lord. 15 and 16. 15, my lord.
Is this the first complaint?
Yes, my lord. 14 and 15, my lord. Annexure 1 series, my lord.
14 and
Annexure 1
15?
series, my lord. 14, 15, my lord. Annexure 1 series.
14 is yes. And 15 is also there. Which one is the first complaint?
This is the first complaint, my lord.
This 14, page 14.
14, my lord.
Okay. So who is this I there?
This is the petitioner, my lord.
This is the present petitioner.
Yes, my lord. The complaint has been made against the respondent, my lord, the present respondent, my lord.
Present respondent.
Yes, my lord. My lord, may I read my lord?
Yes, just a minute. No, complaint against Ramin. Yes,
Yes, my lord. May I read, my lord?
yes, please.
With reference to the subject cited above, I would like to state a few words for your information and kind necessary action, please. That, sir, I had a mail meeting which was brought to home on November 21 and was openly on 1 December 2016. And once we do yet, the GB Darka had approached me to exchange his meeting with my meeting. And in the meantime, while Gamin Padu claimed my meeting as his own, and I informed Sri Duyata that since there is a dispute of ownership, I could not exchange the same with him before the issue is settled. And then, meanwhile, which I have learned that the two had exchanged their respective meetings without settling the issue of ownership of the legality, but the same that Sri Gamin Padu have exchanged his meeting with mine. Therefore, I will at loss if the exchange this meeting is sacrificed, which I have rendered as Ms. Sri Duyata is likely to perform some ritual at any time. The matter had been informed to HDB Darka for information, but I would like to request you to kindly investigate into the criminal act and register a case against the culprit under the relevant provision of the law. My lord, same prayer I have again made in.
Just a minute, so, so is Dui Ete is also a party?
No, my lord, he is not the.
You have not made party?
No, my lord, he is the person with whom the meeting, my meeting was exchanged by the respondent, my lord, without my permission, my lord. This person first approached me to exchange his female meeting with my meeting, but then since there was a dispute between the ownership, so I refused him, my lord, to exchange the meeting. But later.
Then he went to?
Then he went to the respondent, my lord, because there apparently the earmarks of the meeting were similar, so.
Okay, so this Dewey came to you first.
Yes, my lord.
And then the same Mithun.
Yes, my lord.
To be yours.
Yes,
and then you offer an exchange.
Yes, my lord.
Since you refuse.
Yes, my lord.
So Dewey went to
the respondent, my lord.
Respondent.
Yes, my lord.
For the same Mithun.
Same Mithun, my lord. Because since the ownership of the Mithun was disputed, my lord, so he went to the respondent and.
So prior to approach of this Dewey there was a dispute between you and.
Mithun was in my possession till 2016, my lord.
No, you said that it was under dispute.
Yes, my lord.
So because you did not settle with Dewey because there was a dispute.
Yes, my lord. During 2016 only, my lord.
2016.
Yes, my lord. Before that, it was in my possession only.
Although it was in your possession, but then it was dispute.
Yes, my lord. It was disputed, my lord.
With Mr. This one.
Therefore,
the respondent.
Yes, ma'am. That is the reason why I turned down the proposal of Sri Dewey because.
And then you filed this complaint before the Deputy Commissioner.
Yes, my lord.
To find out the fact.
Yes, my lord. Thereafter, my lord, one village level cover was conducted, my lord.
No, thereafter, what did this Deputy Commissioner do? After this complaint, first complaint?
My lord, after this complaint, my lord, my lord, nothing, my representation was not considered, my lord. It has been just lying, my lord. However, my lord.
This was in 19 December.
Yeah.
Yes, then?
However, my lord, on 18, 12, and 2016 and 1912.
No, this is 1912 only.
Yes, my lord.
1812?
My lord, thereafter, one village level cover was conducted.
On the basis of what?
On, my lord, because there was dispute, my lord.
So when it was conducted?
My lord?
When this village level cover was conducted?
It was conducted on 18/12/2016, my lord.
No,
but,
no. So you said that this is the first complaint, 1912.
Sorry, my lord, on 17/4, my lord, 17/4, 2017, my lord.
Or 2017?
Yes, my lord.
Okay. So then
2007
thereafter, Deputy Commissioner didn't do anything on this complaint.
No, my lord.
The
My
next
lord,
step then,
thereafter, my lord, I filed criminal complaints also.
where?
See, before the.
Have you
police-
annexed that?
Yes, my lord.
Let us see.
My lord, I have not annexed the police complaint, but my lord, I
Now,
have-
are we taking up for a hearing? It's in administrative stage. What do you want? Today, detailed hearing probably is required. Or have you explored the possibility of settling between the parties outside the court? Here
Lordship,
in this case,
no, my lord.
Lordship,
NDPS there is.
brief fact, what happened, Lordship?
Hmm.
The disputed Mithun was already decided in my favor on 3
So that is where there are
Kabak decision.
lot of document decisions.
I have enclosed in my affidavit in opposition.
Mhm.
And disputed Mithun was also sacrificed, Lordship, in the year 2016 on the basis
Mithun
of
no more.
Kabak decision. No more, Lordship.
My-
Even
Ah.
on third Kaba, on the basis of the complaint lodged by the petitioners,
Hmm.
third Kaba was conducted,
Hmm.
whereby the Kaba members found that the allegation leveled by the petitioner is illegal and wrong. Therefore, fine of 50,000 was also imposed to the
To the
petitioner.
petitioner.
He also paid that fine. Thereafter, they filed the appeal before the deputy commissioner. And in the appeal, before appellate authority, the petitioner never raised regarding the payment of the fine imposed by the Kaba decision.
You have already paid.
Nothing is left.
Just a minute.
Nothing is left.
Just a
Your
minute.
No, your lordship, I have not paid the
Not
fine,
paid.
my lord. No, my lord.
You have the receipt.
Money receipt is
No,
enclosed.
my lord, that was paid by seven.
I think then I think because there are a lot of Kaba decision and
You just
My
the
lord, this-
documents also. Probably we need a longer hearing. So can we fix it for hearing next week or any day? We'll take it up, settle it finally.
yes. Next week.
Otherwise, it is going to take time.
Yes. Yes.
Hmm. We'll fix it for hearing.
Yes, Lord.
Okay.
I enclosed money receipt also, Lord.
My lord, that was not
Then-
paid by me, my lord.
Now their
Claim
claim is
Money
there.
receipt is also there.
Money-
Just let us see once.
Yes, my
Yes.
lord.
Just a
Take
minute,
up my
My lord, can-
my affidavit in
just a
opposition.
minute,
My lord, even I have enclosed the money.
Page
Lordship, money receipt at phase number 42.
42 of,
42 of my affidavit in opposition.
okay. Is here, no.
43, Lordship. 43 is the handwritten copy, and then
No, just a minute. Affidavit in opposition.
yes,
It's not here. Yeah,
affidavit in opposition.
forty
43.
receipt, okay,
Type copy is 44, Your Honor.
yes,
Head,
to the head gum.
sorry, Your Honor. Type copy is at 42, Your Honor. 42.
Not 44.
Not 40. 42 is the type copy, 43 is the handwritten copy. 42, Annex 5. Money receipt.
Yes.
I see Gamin Padu,
Government Paru is the
respondent here.
petitioner here.
Respondent here, Your Honor. Respondent.
Okay. Hmm.
Son of Pogam Padu, Kandiblaze received a sum of rupees 50,000 from Medamatar, GV, Gaubura.
Hmm.
This amount accrues as a fine from the cover decision dated 29/7/2018 in the matter of Sri Isenatha, which is Nariyat, leveling false allegation against me. Now, what happened, Your Honor? Third cover, which was challenged by the petitioner before Deputy Commissioner, it was passed on 29/7/2018.
Then thereafter, you did not go to the civil court.
No.
isn't it? No,
No.
it has,
And this fine was imposed by the 29 cover decision,
Hmm.
saying that you have leveling illegal accusation against the respondent, saying that he sold your meter. Therefore, he has been imposed fine of 50,000. It was also paid.
My lord.
And these all aspect issues were never raised before the appellate authority. Accordingly, appellate authority
Probably,
On
if
cons-
you are insisting for that, probably it has to be sent before the court below for trial, because it's involved with the question of fact, it appears. But then let us see, we'll fix it, date for hearing. And then in the meantime, have you earlier, whether both the parties have any explored to settle the matter outside the court?
No, Lordship, nothing left there.
Nothing left.
Disputed-
According to you, nothing left.
Yes, yes.
But then still he has filed.
Because
The
Lordship,
petitioner,
Because-
he has
repeated
filed.
Mithun already sacrificed in the year 2016.
16.
Subsequently, on third cover decision, it was decided in my favor, respondent. And accordingly, fine was also against the petitioner, which was already paid also.
Hmm.
So
My
there
lord,
is question
I
of settlement
agreed by
does not arise.
that particular decision only. Therefore, my lord, and the order of the deputy commissioner that I have annexed a sale, my lord, it was passed basing on two reasons. One is that the payment has already been made, number one. But however, my lord, that was not paid by me, my lord. Some Jomia Ata has paid on behalf of me without my consent and my knowledge, my lord.
That
And
was
the-
not
the-
issued before the appellate authority, Your Honor. Even he was never made any statement regarding the famine, and no any action has been initiated. The person, it was his nephew, as per his statement. Payment was made by his nephew, but I didn't pay. His stand is there.
Yes,
But this
yes,
is
my
not
lord.
acceptable because it was not raised
Since
before
my
the appellate
fine was
authority.
imposed on me and I had
Could
no
have raised in the
knowledge
first
whether-
instance. Anyway,
Yes.
so, let us see how this thing. Okay, Mr. Miss Elena,
In
E
that
permit
case, Your Honor, we are jointly praying for the matter to be
Okay.
listed after break,
after break. Okay.
in admission hearing laws for disposal.
On the joint prayer of Miss E permit and counsel for the petitioner and Mr. Loring, J. Loring, and counsel for the respondent. Come at least this matter after
Break,
ensuing summer vacation. Okay.
summer break.
We'll try to dispose of on that day.
Yes, yes, yes.
And you also obtain instruction and then, because no point.
Yes.
And if you insist, then ultimately, since it involves with the
Disputed.
question of disputed fact, no? So then it has to be sent there. Again, you see all those procedures we have to cross. And then if there is nothing left, then it is always better to just settle for something at least. Settle for something. Yes. In the meantime, try to explore.
Deeply obliged.
Hmm. Yes. No one appears on behalf of the parties on call. Case is 10 adjourned. list this matter after 4 weeks. Okay.
Item number 10.
May it please, Lord.
Yes, please.
Lord, this is a matter on the last occasion also we have argued before your lordships. Now, the matter has come up after an injunction order was been passed, quite arbitrarily, my lord. Although, my lord, the plaintiff is required to state all the facts and materials in the plaint. Now, your lordship, after going through the plaint, your lordship will find these are deficient enough in order to come to a specific finding. Now, as your lordship understands, the plaintiff, in order to get an ex parte decree, they must state the facts and materials in the plaint itself, wherefrom if your lordship will be, my lord, convinced that there is a case of injunction. Now, here, my lord, I will demonstrate that there is no sort of any element of giving an injunction ordered by the trial court. Now, my lord, I will take your lordships first with the order which has been passed by the court below. That is, my lord, the order dated 22/12/2023, which your lordship will find at page 166.
This is regarding the occupation of the post.
Beg your pardon.
This matter is regarding.
Regarding, my lord, they wanted to say that there is an amendment of the constitution. Now, if you want to amend the constitution, my lord, that will have to be done by virtue of Article 29 of the constitution, which say that there must be a people assembly. And before that people assembly, my lord, the notice prior, 1 month prior to that, you will have to serve a notice. My lord, nowhere in the plaint your lordship will find that sort of reflection. Okay. Now, how the trial court was satisfied that the people assembly was there, and out of that people assembly, that amendment was done. My lord, it is totally, there is no whisper on it. And on the basis of no material, the trial court has passed an order granting the injunction saying that the subsequent meeting which was held by the present petitioner, that is illegal. Now, very interestingly, your lordship will find in a civil case, one has to, the plaintiff will have to stand on their own legs. Now, here, your lordship will find it is other way around. They were trying to find fault with the defendant case.
Okay.
And ultimately, on the weakness of the defendant, they have passed an order.
Okay.
My lord, the plaintiff will have to stand on their own legs, the habeas court time and again has said. Now, the plaint, I will take your lordship first to the plaint, what is their statement, and whether the trial court was at all convinced with the statements made in the plaint that it is a case of injunction. The injunction was passed that the defendant, who is the chairman, they held an election, that election was stayed. And even, my lord, they were not in a position to use their emblem, seal, all these things. As a result, my lord, in the last election, they could not file their objection against the plaintiff before the election commission. Now, those are the things, my lord, we have been ousted from the fray. And the plaint, they did not say that there was a people assembly. Admitted position, my lord, the executive committee held a meeting. Now, whether the question would be whether the executive committee can amend the constitution. It is where the law says, I mean, the constitution of the PPA has said that the 29 is very specific. It has to be done through people's assembly. And your lordship will never find anywhere. Now, it's a case, my lord, where the learned judge ought to have taken an evidence. They did not take any evidence. Merely on the statement made in the plaintiff, you are satisfied that the people assembly were held. Now, there is no materials. How we have come to that finding? Now, my lord, if I take your lordships to the first, I will take your lordship to the plaint. because that is the foundation of the plaintiff's case. That your lordship will find at page 74. The first volume. It starts from page 82. Page 82. 82. The government in the plain starts from there. The lordship got it.
Yes.
Well, the para one, that the plaintiffs.
Where is the respondent? Respondent is respondent.
Respondent, my lord, your lordship will find at page 75. 1, 2.
The present petitioner is
Present
respondent-
petitioner is
respondent number 2.
respondent number 2. No, my lord,
Who filed this
is
present?
the respondent number? Yes, respondent number 2.
Present petition.
My lord.
So present petition is filed by only one.
Petition is filed by one, yes, Kamal
Only-
Ringo.
Only.
He is the affected person, my lord.
There is only one petitioner here.
Yes.
Okay. So he was the respondent number 2
Respondent number 2.
in the suit.
And the
So
facts of the plaintiff, your lordship will find at page
82.
82.
Yes.
That the plaintiff's People Party of Arunachal, for brevity hereafter referred to as PPA, is a regional political party of Arunachal Pradesh, and the party is registered with the Election Commission of India in August 1977 as required under Section 29. Section 29 is not A, my lord, only Section 29 of the Representation of the People Act 1951, and was subsequently recognized by the Election Commission of India after the first general election of the Legislative Assembly in 1978. Since it is a registered political party, it is entitled to all rights and privileges guaranteed under the Constitution. Now, the plaintiffs would like to bring into your kind notice that in the year 2019, the President and Secretary General of PPA was suspended from the party by the defendant number 2. Therefore, they filed a title suit before the Learned Civil Judge, Junior Division, UPF for permanent injunction. After careful perusal of the record, the Learned Civil Judge, Junior Division decided the case ex parte in favor of them. The Learned Court issued a permanent injunction against the defendant number 2 from issuing arbitrary orders. This is, my lord, the earlier my lord, case and all that. We are not much on it now. Now, para 3. That the plaintiff.
Earlier was also, there was a dispute between the
Yes,
same party.
my lord, yes.
So it was decided in your favor.
My lord. So now we are not concerned about that earlier
No, it is
decision.
in our favor.
No, in their favor.
Okay.
But we are not, presently we are not concerned about that.
Okay.
Now, your lordship may starts with paragraph 3, my lord. That the plaintiffs most respectfully submit, your lordship kindly says there is a submission, not statement. Most respectfully submits that the state executive meeting, this is very important, my lord. State executive meeting was held at the PPA office, Itanagar, dated 24/9/2022, where all the signatories like state executive members, district president, women wing executives, and state youth office bearers were present, and the House President has unanimously decided to adopt following resolution. And as such, Article 13 PPA Central Working Committee shall be discussed in detail by the party executives. The House unanimously decided to do away with the post of CWC chairman, as it has been found redundant, regressive, and contradictory to the spirit of party policies and programs over various crucial issues of state importance like PSC and CC. Henceforth, the party shall be headed by the president. The House also decided to fix the basic qualification needed for the post of the party president. It was decided that anybody vying for the post of the party president should have been an active member of the party for a minimum 3 years. The House was of the unanimous opinion that the party need immediate revamping with appointments of all the existing vacant post portfolios at the state and district level. Fund Mobilization Committee under the chairmanship of Sri so-and-so was mooted and the finalization of the program is to be taken up soon with rest of the members. Mega contract campaign and awareness campaign shall be organized in all the district level and village level. The House President also adopted its solidarity support with AAC in its crusade against the corruption in the state. So the plaintiffs beg to state that as the election was due as the term of previous executive members was over, hence Sri Tava Tagar, a member of PP, was appointed as returning officer for conducting election of PP for the term 2022-2025. Accordingly, the returning officer issued a public notice through newspaper for nomination paper by notification dated so-and-so. The plaintiffs humbly submits that the election was held on 14/10/2022. Well, this paragraph is very important. The plaintiffs humbly submit that the election was held on 14/10/2022 and the results were decided on the same date. Sri Kafa Bengia elected unopposed as the president and Sri Kaling Jarang was elected unopposed as the Secretary General of PPA for the term 2022-2025. The next para is also important. The plaintiff most respectfully beg to submit on 4th November 2022, executive members has convened a People's Assembly and as per the Article 29 of PPS Constitution made 4th Amendment of the Constitution as per resolution passed on 24/9/2022 and removed, amend the post of chairman and laid down 3 years active member eligibility criteria for holding post in executive. Now, Your Lordship kindly see when the election was held, Your Lordship will find on 14/10/2022. And the so-called amendment, Your Lordship will find, my Lord, if we accept the resolution was made correctly, assuming, not admitting, my Lord, the resolution dated 24/9/2022 was passed by the Executive Committee, whereas in terms of the Article 29 of the Constitution, my Lord, at this stage, I think I'll have to take Your Lordships to what the Article 29 of the Constitution. Extra copies there. Or I'll have to take from the book, no? Your Lordship may see the second volume, no? I'm having it. Lordship, kindly take the second volume, page 257. We have quoted to evidence that particular constitution. I'll take Your Lordships to Article 29, which Your Lordship will find at page 268.
(257) is the Constitution.
It starts from 257.
Okay.
Now, Article 29, Your Lordship will find at page 268.
(268).
Yes.
Yes.
Now, Your Lordship, in the left-hand side, in the top, Your Lordship will find Article 29.
Yes.
The party constitution shall be amended only by the People's Assembly. The notice of or proposal for amending the constitution shall be given 1 month before the said assembly. Now, this is the crux of the entire case. And Your Lordship will not find any aberrament in the plaint.
1 month.
Yes.
For the said assembly.
Now, my Lord, who will conduct this for the amendment and all that? Your Lordship has seen. The party constitution shall be amended only by the People's Assembly. The notice or proposal for amending the constitution shall be given 1 month before the said assembly. Now, in order to appreciate this matter, my Lord, there must be some statement in the plaint. Your Lordship will find that there is no statement making that there was a People's Assembly and the notice for 1 month was given prior to holding that People's Assembly. Now, when this part of the thing is missing in the plain, I fail to understand how the learned trial judge was satisfied, how he derived his satisfaction that the People's Assembly was there and the prior notice was given for holding that. My lord, these are absolutely missing in the plain. Therefore, my lord, there was no occasion for the satisfaction of the learned judge to come to that finding. My lord, rather, my lord, their finding was that both by the trial court and the appellate forum, my lord, even if there is some flaw of procedure in not making any People's Assembly, this will not invalidate. My lord, I fail to understand how they can say that. My lord, this is the crux of the thing, and in view of that statement, there would have been an issue ought to have been framed. There was nothing. As your lordship understand, ex parte order when can be given? In an extreme urgent nature, and if the plaintiff, after going through the plaintiff, if your lordship is satisfied, then only it can be given, otherwise not. My lord, the law, I will take your lordship with the various decisions of the appeals court and of this one court, how ex parte order can be given. Now, this is
was
one
ex
of,
parte order.
this is an ex parte order.
Okay.
And then we filed vacation of that ex parte order. That was also rejected, finding the same finding. Now, I'll try to take your lordships to Article 13 at page 265. These are very important my lord, articles in order to decide this case. Article 13 at page 265. PPA Central Working Committee, in the left-hand side, your lordship will find. The PPA Central Working Committee is the highest decision-making body of the People's Party of Arunachal. The PPA Central Working Committee shall consist of the chairman of the PPA State Council, the President, Secretary General, General Secretaries, and 5 other members, of whom 10 members will be elected by the People's Assembly, and the rest shall be nominated by the chairman CWC PPA duly recommended by the President. The chairman CWC PPA shall be elected by the People's Assembly in the conference for a period of 3 years. Then the important part will be 5, clause 5, your lordship can see. The chairman CWC PPA shall be a probing authority of all important decisions of the party. Then 6, CWC shall be responsible for convening the People's Assembly. 7, the CWC PP shall be the final authority in all matters regarding the interpretation and application of the provisions of the Constitution. 8, the decision of CWC PPA shall be final and binding. Now, your lordship will find in the entire case, these things have been flouted, my lord, with impunity.
Article 13(1).
13(1), yes.
13(5).
13(5), 6, 7, these are equally important.
Okay.
Because, my lord, if your lordship, if I take to your lordships to the plaint once again, at page 85, these aberrations are to be looked into, my lord.
Page?
Page 85, paragraph 5.
Yes.
Paragraph 5, your lordship kindly see that the plaintiff humbly submits that the election was held on 14/10/2022 and the results were declared on the same date. Sri Kafa Bengia elected unopposed as the president and Sri Kaling Jerang was elected unopposed as the Secretary General of PPA for the term 2022 to 2025. Then paragraph 6. The plaintiffs most respectfully beg to submit that on 4th November 2022, executive members has convened a People's Assembly and as per the Article 29 of PPA's Constitution, made fourth amendment of the constitution as per resolution passed on 24/9/2022 and removed amended the post of chairman and laid down 3 years active member eligibility criteria for holding post in executive. Now, your lordship kindly see the meeting was held on 14/10/2022, on which date this amendment was, the amendment of the constitution was not there. Resultantly, my lord, the decision of 14/10/2022 has to be ratified by the chairman himself, because till that date, the so-called amendment was there. It was holding the field. Because
So according to you, this, before 14/10/2022, so this was not complied.
yes, this, firstly, my lord, this election itself, I'll take your lordship to the various papers. It was only paper transaction. There was no election at all. And these are the things, my lords, the learned judge ought to have taken evidence. Now, without taking evidence, how the satisfaction has been derived, I fail to understand, my lord. Because admittedly, if the election was held on 14/10/22, then after that, why it was not ratified by the chairman? Because chairman was holding the field on that date. And on your own saying that the amendment was done subsequently. In paragraph 6, it is very nicely clarified that on 4th November 2022, executive members has convened a People's Assembly and as per Article 29 of PPS Constitution, made 4th amendment of the Constitution as per resolution passed on such and such and removed amend the post of chairman. Furthermore, my lord, I will take your lordship to some other papers from my written statement. The draft committee members out of 4, 3 of the members, they have said, this is not a valid amendment.
This is not a.
It is not a valid amendment. In spite of that, the trial judge did not call for those witnesses to prove the case. Now, what was that hurriness that something they will be missing if the injunction order is, ex parte injunction order is not granted? Now, this is the total, my lord, they have flouted the Article 29, then 13(3). Then, my lord, your lordship may come to page 86. The plaintiffs most respectfully begs to submit that the Secretariat of the Election Commission of India on 30/6/2010 and 8/9/2010 asked for updated list of office bearers of PPA. Accordingly, by letter dated 14/10/2022, it submitted the same before the Election Commission of India. However, Election Commission of India by letter dated so-and-so informed that the details submitted are not in a prescribed format of the commission. Therefore, it advised to refurnish the organization election details of the party, along with a complete list of office bearers, members of the committee, etc., elected at such election. Accordingly, on dated 27/9/2023, the plaintiff submitted the details as per the prescribed format of the Election Commission of India. Now here, my lord, your lordship may look into another thing. If you are required to do certain things in a certain manner, my lord, the Privy Council decision way back in 1936, your lordship is aware, I'll place it before your lordship. That decision has said if you are required to do certain thing in a certain manner, you will have to do in that manner only and no other way. Now here, if you are required to do certain things in terms of Article 29 of the Constitution of the PPA, then whether it was done in that manner, it was never done. Now, those are the things, my lord, never appreciated by the learned trial judge. He ought to have considered all these things. He ought to have asked for giving evidence. Now, without doing all that, my lord, he satisfied himself, I don't know from which materials, and ultimately passed this ex parte order. Now, in page 87, my lord, this is another peculiar thing your lordship will find. Page 87, paragraph 8. that the plaintiffs beg to submit that on 4/11/2023, the defendant number 2 issued a circular to convene a meeting by stating that the present office bearer's tenure has expired on so-and-so, as per the Election Commission of India, notified dated so-and-so, and on dated so-and-so, the same is also published in the new daily publication of Arunachal. Now here, my lord, so for the defendant number 2, present petitioner, when their terms expired, they issued a circular for convening a meeting. And then para 9. After coming to knowledge about the circular dated 4/11/2023 and 11/11/2023 issued by the defendant number 2, the plaintiff number 1 issued a press notice dated 11/11/2023 informing party members to refrain from taking participation in the meeting as it is unauthorized and illegal. So the plaintiff begs to state that even after issuance of press notice dated so-and-so with the plaintiff number 1, the meeting was conducted illegally, and once Sri Loki Boje was appointed as the returning officer, and he has conducted the election illegally on dated 12/11/2023. The plaintiff would like to apprise this honorable court that as per the impugned election result dated so-and-so, the defendants are declaring themselves as executive member of the party, thus usurping not only name of plaintiff's association, but its emblem, stamp, and letterpad. This has created a great confusion in the society as there are 2 PPAs now with identical name and emblem. The plaintiffs would be executive member of PPA till 2025 as per the election held on 14/10/2022. The name of its association and emblem cannot be illegally copied to confuse the society at large. The PPA is a registered regional political party. If anyone wants to make a correspondence with the plaintiff, the same might go to the defendants, thus complicating the matter worst in the society. Hence, the election result declaration of so-and-so defendant needs to be interfered with. Now, Your Lordship has seen, these are the only facts before Your Lordship. Now, whether there is any averment that the election which held on 4/10/2022, whether there was any People's Assembly was there, whether any notice prior to holding the meeting, 30 days notice was served at any point of time, these are all missing. So from the plaintiff, Your Lordship will find no case has been made out by the plaintiff to pass an order in their favor. They are saying the election which is conducted by the defendant, the present petitioner, that is defective. My lord, assuming, my lord, for the argument's sake, if there is some procedural lapse, it will give you no cause of action. You will have to stand on your own legs. What is your case? Whether you are entitled to get a decree on the basis of state narrated in the plaint. Now, this is a complete missing of all these statements. Now, Your Lordship may see at page 90, what is their prayer. For declaring the plaintiff's right over the title of People's Party of Arunachal, declaring that the impugned election result, PPA dated so-and-so, is illegal. Now, first thing first, the first prayer is for declaring the plaintiff's right over the title of People's Party of Arunachal. Whether there is any case made out that the election was conducted in terms of law, there was a People's Assembly. In the People's Assembly, it was decided the election will be held on 4/10/22. And after the election, his candidature has been approved by the chairman who was there at that relevant time. Because if we accept the amendment came in later on, even in that case also, my lord, if the election was conducted on 4/10/2022, since which date the chairman was holding the field, then his ratification ought to have been taken. Now, nothing they have stated in their print that it was ratified by the chairman. Then, my lord, in that context, my lord, I'll take your lordships to the order passed by the
That's
learned
the
judge.
election which was declared as challenge.
Yes, 2 is
4/10.
yes. The election which the plaintiff hold it is 4/10/2022. That your lordship will find in paragraph 5. of the print at page 85. These 5 and 6 are the most important paragraph.
14 or 14?
14, my lord. 1410, page 5, that the plaintiff humbly submits that the election was held on 14/10/2022 and the results were declared on the same date. Then, my lord, the next para, plaintiff most respectfully beg to submit that on 4th November 2022, executive members has convened, who has convened a meeting? Executive members. Executive members have convened a People's Assembly, and as per Article 29 of PPS Constitution, made 4th Amendment of the Constitution as per resolution passed on 24/9/2022, and amended the post of chairman and laid down 3 years. Now, Your Lordship, from this amendment itself, it is very clear that the president who was appointed on 14/10/2022, assuming is very correctly done, legally done. Then, my lord, in terms of constitutional power under Constitution 13, Article 13, my lord, that should be ratified by the chairman. If Your Lordship look at once again Article 13, the chairman CWC PPS shall be approving authority of all important decision of the party. CWC shall be responsible for convening the People's Assembly.
Article 13,
Article 13, 456.
456.
Yes. Page kitna tha? Page 265.
Yes.
Page 65, Article 13(1), the PPA Central Working Committee shall consist of the chairman of the PPA. Then, my lord, 5, the chairman CWC PPA shall be approving authority of all important decisions of the party. 6, CWC shall be responsible for convening the People's Assembly. The CWC PPA shall be the final authority on all matters regarding interpretation, application of the provisions of the Constitution. The decision of CWC PPA shall be final and binding on all evening. Now, these are the things Your Lordship will not find was conducted in a very legal manner. Now, my lord, Your Lordship may see the resolution passed on 24/9/2022, which is at page 118. Down below, Article 14, PPA Central Working Committee, as amended on the 4th November 2022. The PPA Central Working Committee is the highest decision-making body of the party. Now, if it was amended on 4th November 2022, then how come you become a president without approval of the chairman? Without the approval of the chairman? Because the chairman was there on that date, on 4/10/2022, if the amendment was done subsequently. Now I will come to this. Even this amendment is also, my lord, quite illegal, because amendment cannot be done by it has to be done by the People's Assembly. Now it was done by the executive committee meeting. And these are all, my lord, the paperworks. Nothing happened in actual field. Then, my lord, Your Lordship may also look into page 110. Who are the drafting committee member? Your Lordship has seen the 111, 111.
Yes.
And Your Lordship will find Sri Kaling Jerang, then Rigam Santana, then Marli Kamki, Sai Tadap. They were the drafting committee members. and how they have conducted, these were never highlighted, my lord. Your lordship may look at page 286. My lord, injunction, my lord, as your lordship understand, it's an equitable relief. And when you approach before the court, you must come in clean hand. 286, my lord. Two 86 is, as your lordship found that, is a quite hazy. Your lordship may see the typewritten one in the next page.
Just a minute.
Is the
After
letter dated?
84,
Uh,
after 284, sorry,
286, my lord.
just a minute. Yes, 86, yes.
Now, this
Is
is
there any
the
type copy?
typewritten is not clear. Next page, your lordship kindly see. The lordship got that.
Yes.
The
86A.
new, yes. The new PPA Constitution Fourth Amendment makes changes to the Article 13, thereby omitting the position of Chairman CWC and instead vesting the powers of Chairman CWC with the President itself. It is to hereby state that contrary to the claims made in the new Constitution book, the draft copy of the Constitution was never approved by the four-member Constitution Drafting Committee, nor any state executive body meeting or People's Assembly was held to approve and ratify the same. The new Constitution book cannot be deemed to be in operation as the same is illegal. After closely studying the affairs of the party leadership and members, I have the strong opinion that the position of Chairman WC is of the imminent necessity and the wisdom of the party leaders to establish such a position within the party was well thought for. Further, the position of Chairman CWC as the custodian, interpreter, and protector of the party and its constitution is paramount, and the same should coexist with the position of party president, unless any amendments are done after following the mandated process. Mandated process, as your lordship has seen, Article 29, 13, and all that. The undersigned is of the strong opinion that PPA Constitution Third Amendment shall continue to be the guiding light of the party. And these are Secretary People's Party. Then the next page, your lordship will find at page 287. This letter is written by Taba Tagar, is the treasurer. My lord, this is a very important.
This was 286 is
286
There's
is
286 one. One is, I don't know, I have got 286 in two places. This is something.
286A.
286.
Is type 1.
Yes, type 1. My lord.
Okay. So I think we have to
Resume it to.
resume it to.
How it's pages. I'm a bit confused. There are
situation demands that. Now, from the materials, ultimately, I will take your lordship to those. This is not a case where ex parte injunction should be given. Now, as your lordship has seen, Article 29 is a must to be proved before the court to show that there was a people's assembly, because amendment is a huge thing.
So at that moment, the present petitioner was holding the post.
Yes, he was the chairman.
Okay, now what is the position?
Now, my lord, because of the interim order, he cannot act. Because even interim order is to that extent, we cannot use the pad, we cannot use the stamp. As a result, what happened, my lord? We could have filed an objection before the election commission because we are debarred to do that.
Okay,
We
what
could
is the
not-
status now? Only the stamp and all that cannot be used by, otherwise the present petitioner is the president.
Yes, chairman. The present
Chairman.
petitioner is the chairman. He's my lord since a long time back.
Hmm.
Now he's a full-fledged chairman, and legally, my lord, still he's the chairman. Only because
What
of
about the respondent, 1 and 2? Respondent.
the present respondent, my lord.
Yes.
Now, by virtue of these interim order, their election, they are saying, my lord, that has not been decided, but they are holding the post of president and general secretary.
Okay, so they are functioning.
They are
They
functioning.
are using their
Yes,
stamp,
everything they are doing.
everything they are using.
Yes,
And
and
except what is the power of this? And you are
I'm chairman.
chairman. What is the power of the chairman otherwise?
Chairman is all in all, man. Any sort of people's assembly, or if any president is appointed, that will have to be approved by the chairman.
Okay, so for approval, it doesn't come now
Now means, my lord, because of the
because of the stay.
arbitrary, my lord, I will say arbitrary ex parte order. Arbitrary, how it is arbitrary, I will show. Because why it is arbitrary, my lord? If you decide certain things without any materials and record, it is called arbitrary. My lord, the learned judge has applied their judgment, but did not apply to its proper perspective.
And then the removal of this chairman.
Removal of the chairman is amendment. Amendment itself is a no amendment. Your lordship has
Okay,
seen.
so
If there is no amendment at all in the eye of law, then, my lord, can this amendment be called to be an amendment?
so do you require to challenge the amendment that separately or
No, here itself.
here
Lord,
itself?
because they have taken an ex parte order by virtue of saying that the amendment was done, the post of chairman is not there. These are all illegal submission, my lord, is based on.
So these section 39.
Yes.
So was it raised before the line court?
Yes,
No.
yes. It was emphatically argued.
Okay.
But
Has it been referred somewhere in the order?
my lord, yes. What is the finding? I'm telling you just
Okay.
one line.
Hmm.
Finding of both the trial judge as well as the appellate judge, that if it is assumed that there is a lapse of procedure also, still then it cannot be said the plaintiff did not have knowledge or they have misled the court. By saying all that, they have passed an injunction order.
Otherwise, by constitution, as per this, it is a must.
It is a mandatory, my lord.
Mandatory.
You cannot rule out that.
Okay.
And,
So
and
whether anywhere, any line, whether this mandatory has come in the order,
my lord, why
it had.
but they will not say obviously because they are passing an order.
Okay.
They did not apply their mind. I don't used to use those languages, but then in fact, if your lordship look at the entire judgment, both by the trial judge as well as the appellate judge, they never apply. They never scrutinize the Article 13, Article 11, Article 36. They never applied. They did not possibly go through it even. And it was working in their mind. If there is some procedural lapses also, even then the injunction can be granted. The finding is that only thing can be done, my lord, it should go back to the trial court and the order should be vacated, because if the order is vacated also now, they are is not going to be prejudiced by it, because they have achieved their purpose. Because
Now, in that case, setting aside, in that case, that the meeting decision
after
to do
setting
away with
aside,
the chairmanship,
no, that of course the position will be changed, because if it's set aside, I'll become the chairman.
Okay.
And
So,
in any case, how is going to be prejudiced?
so
Because-
removal that means his position will be restored.
Yes, yes, his position will be restored.
Okay.
And,
then
and what will happen? My lord, they have filed a suit. Let them prove it there. If they have done everything legally, they can prove everything nicely.
in the meantime, you should be allowed to continue adjournment.
Exactly, my lord. That's the position of law. This is in short, it should go back only, and the trial judge will take evidence and decide the case, because nothing is mentioned in the plaint. There is whether there was a people's assembly, whether the appointment of this president was approved by the chairman, because as on the date of the appointment, the chairman was holding the field. So if he is holding the field, his appointment will have to be approved by the chairman. Now, those things have been given total go by.
So in that case also, I may have to require one list of that.
But that we
In
can
this
give.
case, list of that,
We
along with,
can-
of course, a brief of all those, the section which you have quoted,
My
which are
lord.
challenging, and with that. And if there is any confirmation of or clarification,
My lord.
because it appears that I thought that it would not be for the exposure.
No, it's a factually very
Right.
complicated one.
Mhm.
Unless we assist your ships, it's difficult also. So, well, that list of date we can give, there is no problem. But before that, should I highlight some
Yes,
other
yes.
things?
So before that, we'll have to know the fact of
My
the
lord.
case first. Anyway, so where we were,
My lord, I would like to take your lordships to, before that, I just want to.
probably you have also annexed plaint
Yes,
or
yes,
the plaintiff, the file by the
yes, my lord.
petitioner.
The injunction petition, plaint,
Injunction.
written statement, everything. It is on record. My lord, can I take your lordships to page 263, my lord? This is a constitution. Once again, I am taking your lordships.
263.
263. Article 11. This is a very important article. I missed it. So I thought to point to your lordships.
60?
263.
3.
Yes.
Okay.
Article 11. State executive.
Article 11, state executive.
Yes.
So this is the constitution of PP.
Yes, constitution. Yes. The state executive shall consist of president, vice president, treasurer, secretaries, general secretaries, president, general secretaries of women and youth council, volunteer force, and student front. Number 2, this is important, my lords.
Yes. So, how it is?
Article 11(2), your lordship.
11(2).
Yes,
The
2.
president shall be elected by.
The president shall be elected by the People's Assembly for the period of 3 years.
People assembly means?
People's Assembly, my lord, there will be all the members and other voters, they will be called. There will be total.
So, minimum requirement membership may be there, or all the members means?
All the members and other the voters, they are also requested to attend, because amendment is a huge thing. If you are going to amend it, you must take the consent of all the people. So those are absolutely missing here, my lord.
The president shall be elected by the People's Assembly for the. So People's Assembly consists of all the members of the. this
Your
party.
lordship may also read Article 10, left-hand side down below. The supreme organ of the party for
Article
the
10.
Article 10, People's Assembly.
Yes, yes.
The supreme organ of the party for the whole state shall be the People's Assembly. The conference of the People's Assembly shall be convened by the executive ordinary once in every 3 years. An extraordinary People's Assembly shall be called by the state executives when it is demanded by 2/3 member of state executive the date and venue of the conference of the People's Assembly or of the extraordinary People's Assembly shall be decided by the state executive at a meeting specially called for the purpose. The People's Assembly shall be composed of delegates selected by the block, district and city executives.
Okay.
10 from block and 15 each from the district and city.
Okay, so they'll have to invite delegates from the district.
Yes, yes.
Block, district and city. So this was not there.
This was not there, my lord. It is admittedly. They are saying that executive members, even in the plain in paragraph 3 also, they have stated that. The executive members called that. Now, on the face of it, this is an admitted position that there was no People's Assembly, which is a mandatory part, my lord. ये भी दिखा देंगे ना। घर में लग रहा है ना।
We have bail mates. Can we do it first? Then it will, because it will take all of the day. Otherwise,
I recollect, my lord, the last time it happened
no,
that way.
just bail matters only, because Masini will definitely appreciate bail matters are urgent. If we can appreciate them, not 5 minutes only.
Last time Mr. Majumdar said, I'll take 5 minutes. Anyway, my lord, if this is very urgency, then.
Okay.
I don't know, PT accommodates, let's record this urgent.
So,
Up to your lordship.
This is not now, it's not urgent. It was urgent when the election was there.
no, that is why. Lately, I realized that this is, the election is over now.
At that time, it was urgent. Now,
Anyway, today what we can do is have hearing of the Line Senior Counsel.
Yes.
And then if time permits you or otherwise.
Some other day
But
he can.
because, okay. Do that.
I'll not take much time.
Okay.
Let your lordship may take this.
Let him finish his side then.
No, other parties are also not there. That's why I'm a bit afraid. But if they later on comes and say we didn't, we were not there, but whole argument will become inflexible.
Because Line Senior Counsel has also come also.
No, definitely understand the difficulties Malavi has. Definitely we will accommodate one.
My lord, if I can complete it, my whole problem is this, my lord. I want to go back today itself.
Right. How long it will take yours?
Hardly, my lord, with some decisions are there, I will place it. 40-45 minutes.
That means more than 1 hour.
No, not more than 1 hour. I'll cut short, my lord.
What is the urgency? This is your bail is.
Your lordship, the request made is if the bail and order matters, which if taken will at
Okay.
least.
So we'll accommodate then for some time.
We'll give our senior whole time.
Let us see. Let us see if it is available. Next, where we are. This is item. This is 10. Okay. Item 11, what is this?
Yes.
Huh?
My lord, this is application, the mandatory period, the last occasion we have, there was the main case. Then after that, mandatory period has already reached, already over.
Yes, mandatory period, no charge sheet.
No, it's just it has no point.
Your lordship, the charge sheet has not yet been filed, your lord.
Not yet filed. Mandatory period over.
Yes, your lord.
He is entitled then.
Default bail.
Okay. Have you filed any
Yes,
IA? You have filed?
yes,
It's there.
yes.
Okay. What is the offense involved here?
So 21B, 27, 29 of NDPS Act, your lord.
21 B.
21B, small b, 27 and 29,
So 21 B is 60 days.
60 days.
Okay.
Now it's 82 days. Will be over. Languishing under judicial custody.
Your Lordship will see, he was arrested on at page number 18. That is on 28(3,
Page 18 of
the
I-
main petition,
Hmm?
main petition,
main petition. What is that?
the arrest memo,
Hmm?
arrest memo, Your Lordship.
Okay, just then. Page 18, 1/8.
1/8, Your Lordship. Date,
Okay. This was. This is for regular bail only.
this regular bill, Your Lordship.
Okay. We'll dispose of the IA only.
Yes, Your Lordship. Your Lordship may also kindly record that we have received the CD, Your Lordship.
Okay. Okay. Hard, Mr.
Need to complete it.
Learned counsel for the applicant. And also Ms. Jenny, learned additional PP for the state of Arunachal Pradesh. Para. This is an application under section 167(2)(a)(2) Roman 2 of the Code of Criminal Procedure 1973, praying for the grant of default bail.
Your Lordship, the main petition was filed, Your Lordship, for regular bail, Your Lordship. During the pendency of this,
Bail to the accused, alleged accused, Dr. Pakba, who has been arrested in connection with Nahalagan PS case number 34/2024 under section 21B, 27, 29 of Narcotic Drug and Psychotropic Substance Act 1985. 85. Stop. Para. When the record was called for,
record was called for on 17/5/2024.
17/5
Yes, Your Lordship.
by an order dated 17/5/2024. A scanned copy of the case diary was called for in BA 53 AP 2024. Start. However, during the pendency of the BA 53 AP 2024 comes the accused applicant, not applicant, the accused has already spent more than 82 days. 82 days, thereby completing the statutory period of 60 days. And as such, the petitioner filed this bail, this IA for granting bail to the accused, granting default bail to the accused. As the police, as the IA of the case has failed to file charges within the statutory period of 60 days. The learned additional PP, Ms. Jenny submits, Ms. Jenny produced a scanned copy of the case diary. However, she fairly submitted that the case is still under investigation and IO could not submit the case into charge sheet within the statutory period of 60 days in the instant case. Stop. The learning counsel for the petitioner submits that since the IO of the case has failed to submit a charge sheet into the case within a statutory period of 60 days, the accused is entitled to be considered for release on bail, on default bail. So, the record reveals that the accused was arrested on 18, no? Page 18.
Page
Arrested
18.
on
28 3.
28 March 3, 2024 in connection with the above PS case number 3420. 2024 under section 21B, 27, 29 of NDPS Act. And since then, he has been languished under the police or judicial custody till date, and the police has failed to file charge sheet into the case till date. Under the circumstances, the accused is entitled to be released, entitled to be considered for his release on default bail under under the provision of section 160.
No, Your Lordship, it's under 489 only. 167 is only with regard to statutory period, Your Lordship. But while considering the bail, it's always 489, Your Lordship.
Okay. 489, read with 167 to A2. Huh? Stop. And the court has no discretion in this regard. So, in view of the above, the accused is directed to be released on default bail on execution of a bail bond of rupees. What is the amount normally?
Your Lordship has a discretion to set the amount, Your Lordship. There's no specific.
Normally, the fine
10, it starts with 10, Your Lordship, normal.
okay. In execution of a bail bond of rupees 167, sorry, not 167, 21B.
21B, 27 and 29.
Okay, 20,000, huh? An execution bail bond of rupees 20,000 with two sureties of like amount to the satisfaction of
The Sessions Court, Your Lordship.
session court, the special judge NDPS. Okay, with the subject to the following conditions. Huh? One, that the accused shall appear and cooperate and appear before the trial court. Appear before the IO of the case. Huh? as and when called for. For the trial, I of the case and make himself available for interrogation by a police officer by the IO as and when required. Stop. That the accused shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the fact of the case so as to dissuade him from disclosing such fact to the court or any police officer. With the above.
Your Lordship, if one of the conditions may be that during the period, Your Lordship, he may not repeat the same offense. Offense of any nature.
That the accused shall not repeat the similar offense as he is alleged of commission of the offense. Anything else?
Lordship, it will suffice, Your Lordship. Your Lordship, only one, when Your Lordship has started the dictation, Your Lordship has dictated that the application has been filed under 167. It ought to have been 489, Your Lordship.
It is 489. Is there?
439, yes. Your Lordship has, while dictating, referred to section 167, Your Lordship. That is not the section for bail. 489.
No, 489 I have mentioned here.
Yes.
I have mentioned both.
Yes.
Read with 167.
439, Your Lordship.
Okay. With the above this, the main case, bail application as well as the IA, stands disposal. Okay.
Deep
Next.
This is also an application for bail. In this, what happened, this present accused person, she was arrested on the NDPS Act, 21B.
21B.
Yes, madam.
So 21B, 27 and 29.
27 and 20. The fact of the case is here, the accused was never involved in the matter. What happened here when the investigation took place, the police started interrogation of the other accused person whom they arrested. They named the accused person that she has accompanied them to Assam in the vehicle. That's the only allegation in the entire case.
He has been arrested on the basis of the statement given by
of the co-accused only.
Okay.
Yes.
No, Your Lordship. In fact, her statement is also recorded. She is also an addict, and through her own admission, Your Lordship. They have gone. 3 of the people have gone to procure the substance from
along with the present accused
from Assam, Your Lordship. Yes, the statement of accused herself is there.
No, accused the statement of the accused person will never be
police.
Yes, before the police cannot indict himself. In
Your Lordship, in the stage of investigation, 161 itself is the basis for coming to a conclusion.
That's why, here on the basis of the statement of a co-accused,
basis of that the arrest was made.
What is the name of the accused?
Your Lordship, it's Ponung Moyong.
Ponomoya.
Okay.
Yes.
Okay, so the co-accused is a husband.
Yes,
Yes.
one of the co-accused. Yes. The co-accused name is Kodum Yamso Puni Asa Mosang Malat and Kodum Yamso Puni Mosang. They named, and the husband was arrested.
Husband was also arrested on the basis of the statement of the co-accused.
Yes.
Husband also.
Yes.
No, Your Lordship. Your Lordship will go through the statement, Your Lordship. All three of them. And it's
No.
not the first time, Your Lordship.
Oh,
They have also named from where it was procured, Your Lordship.
so there is also other case pending before against the present accused.
No, Your Lordship. They, in their present statement under 161, Your Lordship.
Okay.
We need not confuse ourselves. Let's read the FIR, what it states, man.
FIR in NDPS case, FIR hardly you find.
No, but Malad, this is the basis because
Yes, of course.
there's basis on which the arrests were made.
Where is the statement?
Your Lordship, I have marked the statement.
Anything seized from the present accused?
No.
No,
Anything?
nothing.
No recovery.
Because the incident so happened, Your Lordship, that the accused, one of the accused who had bought together, they went to Assam, Your Lordship. They have procured it. One of the accused had the substance, Your Lordship. Meanwhile, what has happened? There was another person who had stolen from her possession, Your Lordship. So when that person who has stolen was arrested, that's when the chain of events happened, Your Lordship. Because Your Lordship is well aware that in NDPS case, it's not just a person, it's a chain of person and events that occurs.
When any seizure from the husband of the present accused?
No, because that was a subsequent. However, Your Lordship will see, though possession was not made because that was subsequently after they procured it from Assam in the vehicle of the husband of the accused present petitioner, Your Lordship. They had procured it from Assam, bought it from Assam. Subsequently, one of the accused has kept it in her room that was stolen by another person. Now, when that another person was arrested, that's when, from where did the substance comes, the link was made out, Your Lordship.
She was also user.
Yes. In fact, she's working as a nurse in the state hospital here, TRIMS.
So she said that she possessed, so nothing was recovered from her.
Yes, your lordship will see 21 does not only speaks about possess, it's also speak about sell, purchase, transport, import.
Hmm. So she along with the husband,
And her sister-in-law.
sister-in-law also.
Yes.
She is also addict.
Yes. And the fact that they have traveled way back to the other state to purchase the contraband and get it inside the state, your lordship.
So what about this name from whom they purchased, whether these persons were also arrested?
Yes, your lordship. That's the reason the case, the investigation is still at.
So these
pending.
persons have been arrested on the basis of the statement of this present accused, the one from whom they purchased.
No, your lordship. As I already stated,
So
your lordship.
one from Polo Colony.
Yes, there was one addict who has stolen the purchased contraband, your lordship. When he was arrested, that's when he revealed that where did he get it from. Subsequently, the person from where he had stolen the substance, your lordship, she had revealed.
What is the amount of the contraband recovered from the other accused, the main accused?
10
That's why-
intermediate,
Intermediate, that's why, Malad, the section-
10.9
From how
gram.
many people?
One
One person. Only one person.
One person only, your lordship.
Okay.
Your lordship will see that, therefore, your lordship, the one who had possessed has stolen it, your lordship. It was his position.
Mhm.
The story he revealed was that from where he has stolen, that person was arrested, your lordship, and inquiry was made, and that's when it was told to the police that they had procured it from other state, your lordship.
Except for recovery of from the person
Yes.
who has stolen,
Yes.
any other recovery?
No,
from
your lordship.
anywhere?
No, your lordship. No
On the
recovery
basis-
was.
only on the basis of the statement of this accused and the basis of the statement before the police.
No, your lordship.
Can it be?
No, yes, your lordship. Therefore, I was coming to 21, your lordship.
Mhm.
21 does not speak only about possession, your lordship.
Mhm.
It also speaks about sell, purchase, transport, import, interstate, and export. Now, if a contraband is seized from a person, your lordship, that's why I had also stated, your lordship, that NDPS does not stick to only one person. The chain has to be taken into consideration and followed, your lordship. Now, when he was interrogated as to how did he get the contraband, your lordship, he revealed that he had stolen it from the sister-in-law of the accused, your lordship. Now, the sister-in-law of the accused, when interrogated, has disclosed that 3 of them has gone to Assam to purchase the contraband from a particular person. The process of how it was purchased and brought inside the state was also revealed, your lordship. And the same was also corroborated by the other accused. If the other accused has denied of any such instances, your lordship, then an argument with regard to only their implication only on the statement of co-accused would have come, your lordship. They have corroborated in their own statement. of have going to Assam and then getting the contraband. And all of the accused, Your Lordship will see, has clearly named a person, Your Lordship, who has delivered the substance. Now, if 21B, Your Lordship, though is intermediate, Your Lordship, one accused was arrested on possession. 3 of the accused was arrested on the basis of transportation, import and export of the contraband to the state, Your Lordship, interstate.
When the accused was arrested?
He was arrested on 9th for 9th of April 24, Your Lordship.
April. 9th of April.
Yes, Your Lordship.
If my sister finishes none of them, only I can build my case, ma. If she finishes first.
My only submission would be, Your Lordship, if Your Lordship will see that in NDPS case, Your Lordship, as I have already read 21B, Your Lordship, it's not only about position, Your Lordship. If position was there, then the search, bodily search, that would have been done. Now, in investigation, Your Lordship, 161 is a very important document, Your Lordship. Now, like I have already submitted, Your Lordship, if they had denied and the submission being made that they were implicated only by the co-accused, that would have been a different case, Your Lordship. Your Lordship has gone through the statement, Your Lordship. All the 3 of them has corroborated their own statement. Now, why 21B is because they were
9th of April.
Yes.
April.
How many days?
No, more than 60 days, madam.
No, not more than 60
More
days.
than 60 days.
April.
We filed before 60 days was completed. That's
No.
why, madam, we approached on 6th before this on
9th of April.
On 9th, it was 60 days over. Yeah, I was about to come to that also, madam.
17.
Yes, it's more than 60 days.
More than 60 days now. Because I thought let her finish.
Yeah. Yes.
Yes.
68 days, Your Lordship.
File on IA will dispose of tomorrow.
Yes.
Yeah. So, tomorrow or day after tomorrow? Tomorrow.
Day after tomorrow, madam.
Day after tomorrow.
Because it's late hours, madam, but I think
Yes.
obligement.
In fact, I was just going through some citation with regard to default bail on NDPS. It seems that the topic is before the larger bench, before the apex court. If in the NDPS case, the concept of default bail lies on.
Based on when it is decided.
Yes, yes.
Okay.
Deeply obliged.
Obliged.
Mr. Tapo, Direct Counsel for the petitioner. Also, Ms. Jeannie, Direct IDPP. Case break. Okay. Ms. Jeannie produce the case diary. This is original or scan copy?
It's a
Scan copy.
scan
of the
copy.
Case. Also, case diary. So, case break for by the Direct Counsel for the party. This is matter again.
19th.
Again, on
19th.
19th.
Yes.
Okay. So,
Day after tomorrow. Yes.
Okay. Let this since this is scan copy, let it be here.
Yes,
Yes,
Your Lordship. In fact, Your Lordship, interestingly, this is just an out of record, Your Lordship. In fact, the person whose name has been referred in both item number 11 and 12 are the same person from whom the substance is procured, Your Lordship. It's unfortunately because of the delay in
Yes, ma'am.
investigation.
No, that's why, madam. Obliged, madam.
Deeply
Yeah.
obliged.
Okay. 12 also. No, this
This
is
is
item.
12.
It's item 12, Your Lordship.
11, 12, they're connected, madam.
Okay.
Deeply obliged.
Okay. In 13 also there is IA.
Your Lordship, there was a suggestion made on the previous occasion to file an IA with regard to the interim that was granted for cancellation of the interim bail, Your Lordship.
IA is for cancellation.
Yes, by this date, we have filed the IA, Your Lordship.
Okay.
Now, Your Lordship will see on 19/3/2024, he was granted an interim bail, Your Lordship.
He never appeared.
He never appeared. The
Who
last
for the petitioner.
the petitioner, it seems they have not appeared. They have not been appearing on many occasions, Your Lordship. Also,
Who is the counsel?
the IA had come for the 4th time, Your Lordship. The council was also telephonically informed on the previous occasion when the IA was filed, and the copy was also served to the local council, Your Lordship. Now, if this is the attitude of the accused, Your Lordship will also take into consideration that since the granting of bail in the month of March, he had not appeared, and having no other option, Your Lordship,
Yes.
we were also directed to file the IA for.
So on 30th also they did not appear, but for end of justice, one more opportunity was given.
Yes.
So let a council appear, will also, will take this matter also on day after tomorrow,
Day after tomorrow. Your
will
Lordship.
dispose of day after tomorrow,
Yes, Your Lordship.
appear or not. Okay. No one appears on behalf of the petitioner on call staff. Ms. T. Ginny, the learned additional public prosecutor. This is IA is for the first time.
No, IA had come for the fourth time, Your Lordship.
Mhm.
IA has come for the fourth time, Your Lordship.
Okay. You also obtain instruction in the meantime if the accused had already appeared
Yes.
before the police.
Yes,
And
yes.
probably it might so happen that the accused have appeared and then shown arrested, etc. You obtain instruction till
Yes, yes, Your Lordship.
that updated instruction.
Yes, Your Lordship.
So it,
Update CD, Your Lordship, in that case. Updated
okay.
CD may be
So
called for.
it's prayed for by. Then on Friday.
On Friday, Your Lordship.
Okay. However, for ends of justice, this is matter again on Friday. Friday is on
21.
21. On which date? The learned additional PP cell produced the updated CD.
Yes.
Okay.
Deeply.
After 14 will come back. No? Yes.
Your Lordship, I am representing the applicant, and I have filed an application under section 438 of CRPC 1973, praying for granting of free arrest bail to the alleged accused Rahul Mishra in connection with Bandadeva police case number 20/2024 under section 420.
What is the, 420?
420/34 of IPC.
We've received the case diary, Your Lordship. On last occasion, we are directed to produce the case diary, and the case diary is with us, Your Lordship.
Yes, sir.
Yes, yes, Your Lordship. It's with me, Your Lordship.
What is this case? Criminal? Civil?
Not civil, Your Lordship.
Criminal.
Criminal, yes, Your
Okay.
Lordship. Actually, Your Lordship, there are three more accused are involved in this case.
Money transaction?
Yes, money transaction. They have cheated with the complainant in the pretext of providing dumper, Your Lordship, and taken the money and left from the place of
Was
occurrence.
there any agreement also executed between the parties?
Executed agreement is there, but Your Lordship, from the CD, it clearly reflect the Your Lord dishonest intention. Clearly reflect, Your Lordship.
From the very beginning?
Yes, from the very beginning, and this present accused is the mastermind, Your Lordship.
Okay.
Your Lordship, may I please? In the FIR, the applicant name is not reflected, and moreover, even in the agreement paper, applicant name is not reflected. He is not involved in this case, Your Honor. And May I please read
Your Lordship,
the,
that 161 statement itself will clear everything. Your Lordship, this is the co-accused who was present with the main accused, the present applicant.
that is only the bare,
The applicant is a co-accused.
Applicant
present
is the main accused, Your Lordship. As
Main
per
accused.
now, as per the CV reveals, otherwise, so far as the FIR is concerned, he was not in the picture.
Oh, okay.
But later on, during the course of investigation, it was learned that he was the mastermind and he was present at there, but he was not physically present, but everything is done by him. And later on, he has taken the money and left the place, Your Lordship. It's clearly there.
Practically, the money was accepted by the other one.
Other one, and that money has been given to him. It's clearly there in the.
He was also in the station.
Yes, Your
at
Lordship.
that time.
Yes, Your Lordship.
Somewhere in and around.
Yes, in the this Bandardua, Dikrong Hotel, everyone is there. And Your Lordship, as per the statement of all the co-accused, clearly reveals everything, Your Lordship.
Okay.
He was the mastermind behind it. Your Lordship, may kindly peruse that statement, 161 statement that,
Okay.
yes, I have given it, Your Lordship.
Of one Imran.
Yes, Your Lordship.
Interim granted?
No, Your Lordship. No entry. Why? Because, Your Lordship, earlier before the learned trial court, he has granted an interim protection. But he has not cooperated with the investigation. On that context, his bail was rejected. Yes.
The same accused.
Same accused. And now they approach this honorable court.
for this, I have filed dispense application because due to my ill health, I could not able to appear before the session court and before the IO. But right now,
That was also interim anticipated. That was also anticipated bail. Bail before the.
Yes.
yes, Your Lordship.
Okay.
But that was not my intention that I would not appear before the IO. Because of my ill health only, I could not able to appear.
After default, then you have filed this bail.
Yes, Your Lordship.
So thereafter, you did not file the subsequent bail application before the.
No, Your
Trial
Lordship.
court, no.
They have already cancelled my bail. That's why I am approaching before this honorable court. And if at this time granting me a pre-arrest bail, then
How do you
it would be
expect
very much.
your conduct will be improved? Hmm?
No, if this
Yourself have failed.
bail, pre-arrest bail would not be granted, then there is a apprehension that I would definitely arrested by the IO. And
Yes,
if
yes.
yes,
Yes, definitely, you will be arrested only.
yes, yes, Lord.
But
And
surprise,
arrest,
there is no,
arrest also
there is no
bring him
interim,
to
and IO is
jail,
not yet arresting the accused.
Sorry, Your Lordship.
and it will cost.
There is no interim as of now.
Yes, Your Lordship. The absconding is absconding, Your Lordship.
Absconding.
Yes, Your Lordship.
Then
You
in
know,
that case-
he's not absconding. Whenever the 41
The
CRPC
police
was
is looking for you.
to
There is
him
no
at the-
interim protection. The police is looking for you. Nowhere you are to be found out.
No.
You are absconding.
No, that time also, whenever the 41 CRPC was served, at that time also he was in his native place. And whenever the 41 CRPC was served,
What was the amount involved?
4 lakhs.
4 lakhs.
4 lakhs, Your Lordship.
So
Your Lordship, can you say that in the paper name is not reflected, and even in the agreement paper name was not reflected.
then why you are applying?
And the police that the IO has served me the 41 CRPC. That's why there is a apprehension that
Have you
I
annexed?
may
Have you annexed?
get arrested. Yes, Your Lordship. In page number 31, 32, annexer 6 is the agreement paper.
You are in the same address. If you are not absconding,
Yes, I am in the same address.
same
only.
address.
Yes.
So police is not interested to arrest you, it appears.
In the agreement paper and in the FIR, name was not reflected. Your Honor.
He is
I
absconding, let him
am
appear.
not involved in this case.
Sorry, Your Lordship.
If he is absconding and you are not in a position to arrest them, let him appear.
Well, 41A notice was already given earlier,
They are-
Your Lordship. And
Then they are not appearing. When it was issued long back.
yes,
April,
and
and then from April, you are not been able to find him out.
Your Lordship, and the thing is that this honorable learned trial court has already given him the
So that
interim
is what I'm
protection.
saying. Till
Yes.
then, no protection thereafter.
He's because of his conduct, since he was not cooperating, his bail was
That is
rejected.
why I'm saying he was not cooperating. Now, no protection.
No protection.
Nothing prevent you to arrest him.
Yes, Your
Isn't
Lordship.
it?
Yes, Your Lordship.
Now you are not in a position to arrest him, unable to arrest him.
Yeah, as on
So
that,
it
yes,
would be
he is
better
not in
for
a
you
prison.
also to just this person surrender before you. And then you do your own this one, complete your own procedure.
Yes, that I leave it to your lordship.
So that is what I'm saying. The police is not been able to find him out. Let him appear.
But your lordship,
the
the,
meantime,
if your lordship, if all these things have been taken into consideration, if the conduct, if suppose your lordship, hypothetically your lordship, if accused is absconding somewhere where it is not in the reach of the police investigation authority, then your lordship, in my humble understanding, that will not automatically entitle him for the interim protection, your lordship.
I'm asking you because you are not in a position to arrest him.
You-
Otherwise, this investigation, the other accused person, even if they are also arrested, they have also been arrested, they are all automatically entitled on a default bail.
Why default
And
bail?
no,
No default bail.
Other accused person, you're saying that he's not the main accused.
He is the main
Involved in
accused.
Practically,
The person who is absconding, he is the main accused. He is the mastermind. So far as the
what about the other accused who were practically present on the?
Other
they were
already
arrested, your
granted
lordship.
bail.
They were
Yes,
been
your
arrested.
lordship. Yes, your lordship.
They have released
Yes,
released
released
on
on
bail.
bail.
They are on bail.
They have not annexed anything to that effect, your lordship. Whether they were
In the-
released or
yes,
not, your lordship.
JMC court.
And they are
granted-
co-accused, your lordship. Secondly, your lordship, it is well settled that even if the main accused is not arrested, if sufficient material is collected, even in that case, the investigation officer can file a charge sheet, your lordship. This is well settled now, your lordship.
The applicant is not the main accused. He is not totally involved in this case, Your Honor. From that agreement paper only, we can find out. that
Arrest
he is
arrest
not-
of the main
Not at all involved in this case. And in the FIR also, his name was not reflected.
at this stage, your
Police is
lordship,
only dragging me for
for the purpose of considering the anticipatory bail, what this honorable court has to consider is whether there is a prima facie case against the accused or not, your lordship, and there is a whether the accused is absconding or there is a possibility of hampering and tampering with the evidence or not, your lordship. The status report clearly reveal everything, your lordship.
I am relying my argument on Ernest Kumar versus State of Bihar, where a court held that if the punishment of the offense is not more than 7 years, then custodial detention is not required. And moreover, the applicant is ready to cooperate with the IO. Your Lordship, even in the FIR and agreement paper, my name was not reflected. And if IO will arrest, then it will bring definitely a humiliation, curtails freedom and cast scars in my life forever. Therefore, granting
What is the
me
name of the present accused?
that Rahul Mishra.
Mishra, your lordship.
Is there anywhere reflected how many accused persons so far have been arrested in connection with this case?
Your lordship, I will find out the status report, your lordship.
Have you stated that earlier you were granted anticipatory bail and that has been rejected? Have you stated here in your petition?
Yes, Your Honor. In that annexure number 3, copy of interim order dated 29/4/2024. Now, that time interim were granted, page number 22 to 23. And Your Lordship, that annexure 4, copy of cancel interim order dated 29/5/2024, page number 24 to 25. And annexure 5, copy of dispense application dated 29/5/2024, page number 26 to 30. I have enclosed my medical document also. That time also, the honorable court, that session court has cancelled my
Your lordship,
defense.
In the status
application.
report itself, it has been given, and Your Lordship, may kindly have a look on this statement, Your Lordship. The witness has been threatened, Your Lordship, as per this statement of the.
That is only the 161 statement, but there is no any evidence that the accused has executed money from that Robin Cheda. There is even not any money received. That all are the bare statement of the IO.
This is co-accused.
Yes, Your Lordship. Not the co-accused, the wife, Your Lordship. She has received the call from the, yes, co-accused involved in this offense, Your Lordship. Received the call from the main accused, Your Lordship. Your Lordship, so far as the arrest is concerned, is there in the front page of the status report. The person concerned who were arrested in connection with this offense in the very first page of the status
Which
report.
page?
First page, Your Lordship, very first page from the beginning. Yes, Your Lordship, there everything has been reflected who were arrested in this case.
This is hot search of
Yes, Your Lordship.
which co-accused.
Yes. The person actually, what has happened in this case, Your Lordship? The complainant approached Rahul Ray, Your Lordship, whose name is there in the FIR, for arrangement of dumper. So Rahul Ray contacted this person, the present bail applicant, Your Lordship, for management of this dumper because he was well acquainted with that person. So he has admitted, he stated that he is the owner of the dumper. So in context of that, he instructed Rahul Ray to enter into agreement with the present complainant, despite he is claiming to be the owner. And after entering into the agreement, he has taken the money from Rahul Ray. And after taking the money from the place of occurrence, he left the place of occurrence, Your Lordship, the main accused. He didn't come under the come in the picture. He didn't appear before the complainant. That is the reason his name is not there in the FIR, Your Lordship. He was done with everything behind.
So this Rahul Rai
Yes, Your
is the
Lordship.
one in between.
Yes, Your Lordship. And he entered into an agreement. Your Lordship, it's clearly there in his statement, Your
Is
Lordship.
Rahul Rai is the main accused.
No, Your Lordship. Rahul.
But the Rahul Rai in the name of this accused.
Yes,
No, Your Lordship. Rahul Roy has been instructed by the main accused to enter into an agreement.
But he never appeared.
He never appeared, Your Lordship.
That is all. That is only the bare statement, Your Honor. That there is no any proof that he is involved in this case. Agreement paper itself shows that real owner, actual owner name is Mr. Deboji Chutia, and the applicant name is Rahul Mishra. So it indicates that he is not involved in this case. Police also have no any evidence against the accused. They are only dragging him into this case. He is not related to this case, and in the agreement paper also, that engine number and the vehicle number also is different, Your Honor. So then how come he'll execute money without giving his vehicle on rent?
Why you have paid so much money without even meeting the person who is
No,
going
no,
to
no.
deliver?
I'm not at all involved, and I have not taken any money from the complainant, neither from Rahul Ray.
The one, the informant. Okay.
Even informant also revealed in the FIR mentioned that
Miss
M. Nosi.
M.
Nosi.
Nosi, Learned Counsel for the petitioner. I've also heard Mr. Ete, Learned Additional PP, Government of Arunachal Pradesh, staff. this is an application. Praying for the application under section 438 of CRPC 1973, praying for granting pre-arrest bail apprehending his arrest in connection with Bandardua PS case number 2024 under section 420 34 of IPC Indian Penal Code 1860. Start. Para. The case of the petitioner is that basing on the FIR lodged by one Sri Robin Cheda before the officer in charge, police station Bandardeva, inter alia alleging therein that one Mr. Rahul Ray and his associate has cheated and cheated him how much amount you said?
4 lakhs your
No, no.
3 lakhs
Eh,
60,000.
not cheated, enter into agreement with him and him for delivery of what?
Dumper, your lordship.
Dumper. One number.
Yes, dumper. That dumper also is not mine, Your Honor.
Okay, dumper for which he paid rupees and for which he had to pay rupees 4 lakhs. No, for which he had paid rupees 3,60,000 out of the total amount of rupees 4 lakhs.
In case and 40,000 online transaction.
Okay, okay. Oh, paid total?
Yes, your lordship. 3 lakh 60 cash.
4 lakhs, 3,60,000 in case and 40,000
Via online
via
transaction.
online transaction. In whose account? In whose account it was paid?
I think Rahul Ray.
Initially, the 40,000 was
Because
40,000 was transferred in
violation
Rahul.
report against Mr. Rahul Misra.
40,000 in Rahul Ray and your lordship 3 lakh 60 in hand of Rahul Ray only, your lordship. Later on, it was transferred to the Rahul Mishra, your lordship.
Rahul Misra.
Okay.
Then there's any evidence that
Okay.
Rahul, the money is transferred to Rahul Misra's account?
However,
I have not submitted any document,
however, after
any evidence against the alleged accused Rahul Misra.
receipt of money, the alleged accused. After receipt of money, he did not contact or what?
No, he did not receive. That time also, your lordship, he did not come to the Arunachal. And
No,
moreover,
No, the main accused. What
yes,
did he, after
main accused is
acceptance of
Rahul
money,
Ray.
what did he do?
Your lordship,
Just a minute.
the Rahul Ray, as per the statement, your lordship, after receiving of the amount, all the amount has been given to Rahul Mishra, the present applicant.
No,
No, no,
your
thereafter,
lordship, no broker will
he
do any work
He
without any
abscond from,
documentation and
abscond or he did not
his
contact
money
the.
He
informant.
abscond from place of occurrence, Your Lordship.
Okay.
They know,
There-
even
However-
they try to find out, but Rahul Roy was
Okay,
found
however,
there.
thereafter, the accused Rahul Ray fled the spot, place of occurrence, and never to be.
No, Your Lordship, Rahul Ray was there. From the place of occurrence, Rahul Ray was found and he was arrested. But
Okay.
the Misra, the amount was given to the Misra.
Okay.
That is the fact, Your Lordship.
that is only the bare statement, Your Lordship. There is no any proof that he has taken money from the complainant or either from Rahul Ray. Rahul Ray is the
That will be
main
decided
broker.
during trial.
Well, some suspicion.
Rahul Ray is the broker and he only took money. I am not at all involved in this case, Your Lordship. And in the FIR also, complainant also said that when called to Mr. Rahul Misra, that time also he denied that he even not taken a single penny from Rahul Ray.
According to their case, Your Lordship, the Rahul Ray asked the complainant that he will refill the diesel in the dumper truck. And he requested to keep moving ahead and they will follow up accordingly. And they left with their friend and waited them in the market area, Your Lordship. According to their case, this is their case, Your Lord.
Yes, whenever they caught in the hotel room, that time also, if Rahul Misra is involved, then he may be caught that time. But that time also he was not there.
However, the accused
Your Lordship, I am
neither
totally
returned the
innocent. I
money
am not
nor
at all involved in this case.
delivered the dumper stock. During his statement, basing on the above FIR, our case was the above PS case being, what is PS case? Being number 2024 under section 420-34 of IPC was registered and arrested accused Rahul Ray. Who stated, in his 161 statement revealed the name of the present accused and basing on the statement of the accused Rahul Ray, the police, the IO of the case has issued notice under 141A CRPC 1973. Hence, he has a reasonable apprehension that he may be arrested at any moment in connection with the above PS case number 2024. Hence, this application start.
Your Lordship, the learned court below order has also be mentioned, Your Lordship. On 29 for
the learned
Annexer 3, page 22, Your Lordship.
produced the case diary, and I produced the stuff. The record reveals that earlier on 29/04/2024, the accused applicant was granted interim anticipatory bail with certain conditions by the
29
sessions, by the sessions judge, UPI. So, however, subsequently from
29/5/24, page number 24, Your Lordship.
Your Lordship, I have, that time I have submitted that
29
defense application.
However, subsequently by an order dated 29/5/2024, the said interim anticipatory bail granted to the accused applicant was
Vacated and cancelled.
vacated and cancelled. Stop. And this is the subsequent pre-arrest bail. The subsequent pre-arrest bail under 438. Praying for grant of anticipatory pre-arrest bail. Okay. Stop. When it was issued, notice?
41A notice was 11/4/24, Your Lordship. It's page number 21, Your Lordship.
FIR was lodged on?
FIR was lodged on, Your Lordship. It's on 27/3/2024. Received on, Your Lordship.
Okay.
27/3/2024.
The record reveals that the FIR was lodged on 27/3/2024. 2024. And basing on the statement of the accused, co-accused, notice under 41A CRPC was issued to the accused applicant for his appearance. However, on 29/4/2024, the accused was granted. Accused was protected by the interim anticipatory bail by the session judge. And thereafter, subsequently, it was cancelled on 29/5/2024.
That time I
It
filed
appears that- it
dispense
appears that-
application also, Your
It
Lordship.
appears that after 29/5/2024.
I filed dispense application.
Hmm?
That time, whenever the learned judge, session court judge had rejected my, at that time I have filed dispense application also along with the medical document.
The accused is not under protection of any interim bail. And the police has had a
Yeah.
liberty to arrest him.
Your Lordship, I prayed, Your Lordship, this anticipatory bail will be maintainable or not. I'm extremely sorry, Your Lordship, I'm submitting this, but Your Lordship, I've come across the judgment wherein it says when the court has granted interim protection, he's come under the constructive custody of the court. And when the interim bail is cancelled, then the accused have to file a regular bail, Your Lordship. He has to surrender immediately. I will, Your Lordship, satisfy Your Lordship with the judgment, Your Lordship. Because with just now, Your Lordship, I'm extremely sorry I'm being delayed, Your Lordship. But once anticipatory bail, interim protection has been granted, then Your Lordship, the subsequently they have to file a regular bail by surrendering the same, Your Lordship. I will, Your Lordship, satisfy Your Lordship with the judgment, Your Lordship.
Please.
Just, Your Lordship, I will find out, Your Lordship. It's there only, Your Lordship.
non-appearance of the applicant is unintentional, Your Lordship. That time, my health was not.
It can't be. It was open for you to appear any day before the police. You could have just appeared before the police with this, an application, attendance.
He was ready to appear that time also, but due to ill health only, he could not able to appear before the IO and before the session judge. And now I am ready to appear before the IO, only if granting me interim relief.
Your Lordship, I will read, Your Lordship, this is Honorable Supreme Court judgment in Manish Jain case, Your Lordship. Well, I will just read out and Your Lordship may peruse it. The petitioner was granted regular in the prosecution under section 50 and so on. So suffice it to observe that the bail then came to be cancelled because of non-appearance. Proceeding of under section 17 for IPC ensued, leading to his arrest, pursuant to which he was released on bail. The petitioner now seek anticipatory bail pursuant to cancellation of SLP, Your Lordship. His bail was cancelled later on, Your Lordship. A person released on bail is already in the constructive custody of law. If the law required him to come back to custody for a specific reason, we are afraid that an application for anticipatory bail apprehending arrest will not lie. There cannot be an apprehension of arrest by a person already in constructive custody of the law. We therefore reject.
That was after release only, I think.
Yes, Your Lordship.
That was after
release.
Here is the case here where
Was granted interim protection.
Interim protection only. He never appeared.
He never
He's
appeared.
seeking the same interim protection.
Yes, Your Lordship. But
One time he never.
Your Lordship, but so far as the interpretation is concerned, when the court grant an interim protection, the accused automatically come under the constructive custody. Constructive custody means, Your Lordship, although the accused is not in the physical custody, but he is still in the control, physical control, and Your Lordship is still in the control or supervision of the court, Your Lordship.
Whether the anticipatory bail was directed to appear before the police or just anticipatory bail was granted.
Yes, he was directed, Your Lordship.
Directed.
Yes, Your Lordship.
Then no.
That time only I have filed dispense application because due to ill health only I could not able to appear before the IO and the learned session judge.
Now here also, Your Lordship, the Honorable Supreme Court says, a person released on bail is already in constructive custody of law. If the law requires him to come back to custody for a specific reason, we are afraid that the application of anticipatory bail apprehending arrest will not lie. There cannot be an apprehension of arrest by a person already in constructive custody of the court of law. We therefore reject the prayer for anticipatory bail. But if the petitioner surrender within 2 weeks from today and seek regular bail, we direct that it shall be considered on a very same day.
No, so constructive custody.
Yes, Your Lordship.
I think that is only after release only.
Yes, Your Lordship. He was.
So then because he is under custody,
Yes.
under bail only. So that is of course.
Yes,
But
though-
here is the case where he
Your
has
Lordship,
not yet been arrested.
the two circumstances is there, Your Lordship. First is he was in interim protection. If suppose that interim protection was vacated, Your Lordship, vacated by after considering the merit of the case, then no doubt, Your
No,
Lordship,
he never appeared. Never appeared.
he
One
has
time
Practically.
yes, he practically
One
never
time
appeared, Your Lordship, but his bail was cancelled. His bail was cancelled for
Cancelled because he did not appear.
yes, Your Lordship. He's not cooperating or disregard the court or
constructive custody, probably. What is constructive custody?
within the Your Lordship, it's a
If
control
the person
control
is
of the
under
court.
bail, then of course that can be, but then he never appeared.
you also may read this that Ernest Kumar Barkil state of Bihar judgment, page number 5.
Okay, considering the nature of offense and the allegation against the accused, that against the accused by the co-accused, basing on which the accused has been issued a notice under 41 of CRPC. And also I'm of the opinion that the accused can be granted anticipatory bail, interim anticipatory bail with certain conditions. So accordingly, you surrender before the police.
No, if interim may be granted, then I would definitely appear before the IO.
The accused shall surrender before. The accused is ready to surrender before the police. Accordingly, the accused is directed to appear before
How
the
many
eye of the case.
to grant me interim relief?
Eye of the case within 15 days from today. And on such surrender, the accused shall be granted. The accused shall be released on anticipatory bail on execution of a bail bond of rupees 50,000 with 2 surety of like amount to the satisfaction of the eye of the case, with the further condition that the accused shall appear and cooperate and appear before the eye of the case as and when called for, that the accused shall not hamper or tamper with the evidence of the case, and that the accused anything else, any other condition?
Your Lordship, cooperate with the investigation, that much will suffice, Your Lordship.
Okay. It is made clear that in case the accused failed to appear before the eye of the case within the stipulated period of 15 days from today.
Your as and when call for, Your Lordship,
No.
as and when call for.
Hmm?
Appear as and when call for, Your Lordship.
And violate the bail condition, above bail, any of the above bail condition, the anticipatory bail granted to the accused
And,
automatically cancelled. Okay.
Your Lordship, we have to, even if Your Lordship mention in the order that automatically cancel, it become difficult for us, Your Lordship, because.
Okay, then on notice or what?
Your Lordship will approach
State
this court,
cancel.
Your Lordship. State will approach this court for cancellation of the same. Your
Okay.
Lordship.
Okay.
And second, Your
okay,
Lordship.
then the anticipatory bail granted to the accused shall stand cancelled.
Yes, Your Lordship.
Okay.
Yes. And Your Lordship, the one more prayer, Your Lordship. Since the accused is from outside the state, Your Lordship, one local surety, Your Lordship.
Okay. Okay. Then two sureties. One of them from the one of them being a local surety.
Local surety, yes. That much, Your Lordship. Oblige, Your Lordship.
Okay.
Return the CD.
Item number 10.
If I may pray, Your Lordship, if
Yeah.
Your Lordship take item number 19, Your Lordship.
What is
19, Your Lordship, we have preferred in CRP, Your Lordship. However, the IA is for condonation of delay of 35 days, Your Lordship. In this matter, only notice may be issued in the IA, Your Lordship.
But if your Lordship can, has the item 15 been taken, but I'm online, but the items called being not been.
Oh, no. 15.
Yes, my lord.
15. Okay, 15. What is this?
Here, Your Lordship, the private respondent were directed to file an affidavit, Your Lordship.
My lord, kindly have a look at the last order and order dated 14/3/2024, my lord.
Last order?
30th of May, my lord.
Yes, yes.
And then your lordships could see the order dated 14/3 for a moment.
Just a minute. Just a minute.
Let me see.
No, affidavit not yet filed.
Not filed
that
yet,
is
your
correct.
lordship.
Not yet filed. Okay. You are Mr. Hart, Mr.
R. Dubey, my lord.
R.
Rakesh Dubey. I represent the petitioner here in my lord. I represent the petitioner in this case.
Okay, land counsel for the petitioner. Stop, Mr. Mehta. This is criminal petition. Okay.
I am for respondent number 1, your lordship.
Okay. You were to file affidavit.
No, your
Okay,
lordship. The
question.
private respondent, your lordship.
That's why I was showing you lordships the order dated 14/3 for a moment, my lord. What has transpired in the court, if your lordship could see, and my lord, now they are shying away from filing that affidavit.
Actually, what happened in this case, your lordship, they have relied some part of the document of the case diary. And when and upon query of the court, they have stated that they have obtained it from the concerned court with the leave of the court. So this honorable court has directed them to file the order of the concerned court, who allowing them to take the extract of the CD, your lordship. For that, your lordship, they need to file an affidavit, as on that they have not filed.
Okay. The respondent number 2. Has not yet filed. They were directed to file
Affidavit, your lordship.
affidavit. And then this was also treated as part her.
It was released, your lord. Last
Lord,
occasion
it was released, my lord.
Released, your lordship.
It was released.
My lord,
Yes,
Justice
your
UK Nayar's court was hearing the matter, my lord. If your lordship sees that 14/3 order, now, my lord, in spite of that order, my lord, on last occasion they did not file. My only prayer is, my lord will give one more chance to them, and my lord will indicate if they don't file it, my lord, the necessary consequences will follow.
Mr. Ether Leonard, additional PP is present. Stop. In absence of in view of the above, the matter is staying adjourned. The respondent number 2 is given one more chance for in interest of justice. The respondent number 2 is given one more chance to file their affidavit. Stop. List this matter after
2 weeks, your lordship.
2 weeks. Okay.
My lord will indicate, my lord, that if they don't file, my lord, the necessary consequences will follow, my lord, because your lordship has
I
seen.
think that will automatically follow.
My lord, if your lordship can kindly indicate, my lord, what has happened, your lordship has seen. Otherwise, this is the last chance given to them, my lord.
It's okay.
Because, my lord, they are, my lord, running away from your lordship.
They are also not there.
No, that is the fact, my
Because
lord.
they are-
Last occasion also, my lord, they being there, my lord. My lord will see, my lord, judicial proceedings, how it been.
Is it quashing petition?
Yes,
Yes,
your
my
lord.
lord.
Let them appear, your lordship, then your lordship. Let
Let
them
them
appear,
appear.
your lordship, at least, your lordship.
Okay.
Deeply obliged.
Could your lordship give a fixed date, my lord? My lord, I am led by a counsel from Supreme Court of India, my lord. If your lordship can give a fixed date, my lord, in the matter.
Fixed date.
Your
My
lordship,
lord.
not if they file, your lordship, my senior learned brother is
My lord,
already getting
my
recognized,
friend
your
appear
lordship.
on behalf of the prosecution, my lord. He should not, my lord, whether they file or not, my lord. My lord, it's my petition, my lord. What I am praying only is that your lordship may give a fixed date so that I can communicate to my counsel at Delhi also, my lord. What I am praying for is a fixed date, not depending upon their filing, my lord. Otherwise, your lordship would see
And
earlier order also
after vacation.
After vacation, then your lordship.
a fixed date, my lord.
No, date. Is paid for by the land counsel for the petitioner.
18, your lordship. 18, your lordship.
On
18, your lordship. Yes.
18/7. Okay.
It is. I am so deeply obliged.
Obliged, your lordship.
May I please,
What was 19 was that?
item number 19, your lordship, since your
This is
lordship.
only notice to be issued.
No, your lordship, if this matter is fixed tomorrow, your lordship.
Matter. Okay.
Item number, because
okay,
as,
19, huh?
yes, because of the item number 10, I don't think this court
Yes,
will be able to take up the matter today, your lordship.
Okay, is prayed for by the land counsel for. You are for?
I'm for the petitioner, Your Lordship.
Petitioner.
Mm.
Miss Jenny, list this matter.
Tomorrow, Your Lordship.
Tomorrow, I think list already prepared, day after tomorrow.
Tomorrow in supplementary list because only for the condonation of 35 days is there.
Okay.
After condonation is done, Your Lordship
But
will
other
take it.
side present,
No, this has come up for the first time, Your Lordship.
first time.
Yes.
Okay, only notice is to be
Yes,
issued.
yes.
Okay,
Tomorrow, Your Lordship.
Okay,
Supplementary
tomorrow.
hearing. Deeply obliged.
okay, yes. Yes, yes. This, I think there is no urgent, I think all the urgent matter we have already taken. What about the other matter? Other matters are,
Item
That is not urgent, so we are not mentioning.
Yes.
Let
okay,
it be there
okay,
when
okay,
it comes
yes,
up.
yes. Yes, 10,
कहाँ बोल रहे थे हम लोग? Lord, we are possibly referring certain provision of the Constitution. I took your lordships to Article 11(2). Then, my lord, कौन सा? 10, yes. Article 10 also we have read. Then your lordship.
Article 10 of Constitution.
Yes, yes. Then 11(2) we have read. Then 36, my lord, your lordship can see once again. 36 we did not read. Six. 36, your lordship will find at page 269. Yes. Article 36. Left hand side, your lordship will find.
Just a minute. 10, 11, 2.
10, 11, 2.
10 is regarding
10 is a People's Assembly. People's
Assembly.
Well,
So 10, entire 10.
enter 10.
Okay, then 11, 2.
11, 2.
Is regarding president shall be elected by the People's Assembly
Yes.
for a period of 3 years. This is regarding president. What about the chairman? You are chairman?
Yes, I'm the chairman. my lord.
And then what is the tenure of the chairman?
3 years, my lord.
Tenure, so he was last elected in the year 22.
Yes.
Okay. And then what is 36?
36, your lordship may look at page 269. Functions of People's Assembly. This is also important, my lord.
269.
269. The lordship will find in the left hand side, Article 36.
36. Yes, functions
Functions and powers of People's Assembly are as follows: to discuss and act on the political and organizational report of the state executive. B, to discuss and change the party program and constitution. C,
Okay, to change the constitution.
yes. This is the functions of the People's Assembly.
People's Assembly.
Yes.
So here in this case, People's Assembly was never
held.
Never held.
Mine.
Okay.
Then
So-
C, to determine the party line on current situation. D, to elect the state executive by secret ballot. Now, on 4/10/2022, there was no voting by secret ballot. They wanted to show.
elect the state executive by secret ballot.
Yes.
So here, not only the president and secretary, but the other executive body was also elected.
Through secret ballot.
Well, it has to be by through secret ballot, but then here in this case.
Here in this case, they have shown unopposed. There was,
Unopposed.
my lord, what we say,
Okay.
there was no election as such. There was nothing. It was all on paper.
Okay.
That's why all these things happened.
Okay.
So it was a case out and out where the satisfaction of the learned judge will come after taking evidence. not this way.
Yes,
That they have filed a plaint and you are giving an injunction order.
right.
This is a totally, my lord, cursory manner the order was passed.
Okay.
Then, my lord, I will take your lordship to some other
That
page.
the relevant is 36
36
B.
B, D, both B and D.
Okay. And
13 बोला नहीं क्या? My lord, your lordship, look at Article 13 also. Your lordship has seen it, but once again, I am drawing your lordship's attention.
13 is at page
At page 265, 265.
Yes, 13(1).
13(1), the PPA Central Working Committee shall consist of the chairman of the PPA State Council and so and so, so and so. Then 5, the chairman CWC PPA shall be approving authority of all important decision of the party. 6, CW shall be responsible for covering the People's Assembly, convening the People's Assembly.
So according to you, that all these constitutional provision under PPA has been violated.
Yes.
By the present
Exactly.
respondent.
Yes, my lord.
Okay.
And then, my lord, 29 to दिखा दिया ना? 29 also your lordship has marked possibly. My lord, once again your lordship look at page 268, my lord.
268. Yes, 29.
29.
Amendment.
Yes, the party constitution shall be amended only by the People's Assembly. The notice of proposal for amending the constitution shall be given 1 month before the said assembly.
So basically your line of argument is here that it was the amendment.
Yes. It was not legally conducted.
It was not illegal. So they could not have.
Yes.
So no notice. 1 month shall be an proposal for amendment of the constitution should be given 1 month ahead.
There should be notice.
So,
one
no
month
notice.
ahead.
No notice.
There is no notice. And the plaintiff is silent about all this.
Okay.
293. No? My lord, your lordship now look at page 293. This is regarding amendment. There was objection from some of the drafting committee members. No? All of the drafting committee members.
293.
293A is the
This is a
typed copy.
This is a clarification to PPA president letter.
Yes.
Type copy.
Informing.
This was given by whom?
Is given by these draft committee members, Ringam Santhana, then Tai Tadap, Marli Kamki, Tawatagar.
No.
293A. First page, your lordship will find 293A, then B, then 294. The name of the person your lordship will find at 294.
94.
Yes.
Just a minute. Name of the person?
Yes. Ringam Santhana.
294.
294, yes.
Okay.
Whereas question of amendment, your lordship has got it.
Yes, sir.
Question of amendment to article so-and-so or removal of CWC chairman does not arise. Hence, your kind authority is prayed not to confuse or feel ambiguity about the party's constitution. The party's constitution is vividly expressed, the power and functions of the members of the People's Assembly and others therein. Therefore, your august office is pray to convene the People's Assembly as soon as possible by virtue of expiry of the PPA tenure on 22nd December 2021, and it's a matter of serious urgent. Now, these are the 4 members who said that the amendment of the party's constitution cannot be done just like that.
So,
And what was done, it is quite illegally.
okay, so these are also vice president.
Yes.
This was given to whom?
Given to the chairman, my lord, chairman CWC.
Chairman.
That your lordship will get at page 293A, page 293A.
Whatever this 293A is addressed to chairman,
Chairman.
but who has written it is not there.
Yeah, written these 4 persons, my lord. Your lordship.
Okay, so this is continuation of this
Continuation,
293A.
right. First is 293.
93.
Yes. Now, typed copy, your lordship will find 293A.
Okay. Okay, the middle 293A and B is only typed copy
Yeah, typed copy, right.
of this 293 and 294.
Right, right.
Okay, okay.
And 293 and 294 is the original copy.
This is
Okay. The same, this one, no?
no. This is this letter was written to the chairman
Yes.
by this 4 person when the chairman was still in the chair.
Yes, yes.
24.
My lord.
This is 24/10/2023.
24/10/2023.
Just a minute. When the chairman post was removed, it says.
Just a minute. My lord, your lordship will find the interim injunction was given on 22/12/2023.
Okay, 22/12. After
Yes.
this.
After this.
22/12/2023.
23. Your lordship will find it at page 166.
Okay, this is prior to that.
Prior to that.
So, on this 24/10, the present petitioner was the chairman.
Yes.
What they wanted to say here?
Now, they wanted to say that, my lord, I am reading that page once again. Your lordship may see
Type
at page
1.
293, type copy. With reference to cited above subject, we the undersigned would like to clarify the reply made by the President PPA in the following few lines for your kind clarification. That, sir, it is a misleading information that Article 13 has amended and the post of CWC chairman has removed, which stated in his letter is purely a malafide intention to defame the great reputation of PPA, which founded by your great former leaders of the party. The letter replied by the President is deviated from the facts of the matter and tried to escape from realities. The fact is that on 24 September 2022 was an executive meeting to take a resolution to proposed for amendment of the Article 13 by covering a People's Assembly to seek consensus to adopt the amendment of People's Assembly. Unfortunately, the Article 13 amendment procedure has precisely
Article 19.
29. Sorry, 29.
So 29.
Yes. The amendment procedure has precisely written that the party constitution shall be amended only by the People's Assembly. The notice or proposals for amending the constitution shall be given 1 month before the said assembly, and evoking said Article 29 never been conducted till today. It is yet to convene the People's Assembly for party organization election and in due course of time, the Article 13 or any other article subclause the party's constitution. This is the last page, no? Then where is the, then 294, Melon? Whereas question of amendment to Article 13 or removal of CWC chairman does not arise. Hence, your kind authority is prayed not to confuse or feel ambiguity about the party's constitution. The party's constitution is vividly expressed the power and functions of the members of People's Assembly and others therein. Therefore, your august office is prayed to convene the People's Assembly as soon as possible by virtue of expiry of the PPA tenure on 22nd December 2021, and it is a matter of serious urgency. Your sincerely.
The interim order was passed on to 10/12.
22/12/2023.
No, this says that People's Assembly as soon as possible by virtue of expiry of the PPA tenure.
Yes.
Okay, tenure.
Tenure expires on 22nd December
21.
2021.
21 only.
Yes.
So, but this was written on 23.
23 for holding the election and all that. But then regarding the amendment of the my lord,
What does it mean? The chairman to whom they have addressed,
yes,
his tenure expired on 2021.
Yes, 2021.
So now, but they have written on 2023.
Yes. The election was not held.
So, but since the election was not held, he continued to be
Yeah,
the
he
chairman.
continued.
And then how do we, these two pages, 293A and 93B,
Yes.
are they connected with this?
Yes, they're connected, Milo.
So no,
Actually,
because see, this is,
294
it
and
appears that this doesn't belong to this application. This is not a part of this application. It
Milo,
appears.
your lordship,
Not in the,
293 and 294 are the original copy.
yes.
And the 293A, 293B are the typed copy. No, actually, my lord,
No.
293A, 293B is the typed copy of 293.
Okay,
And
just a minute. Party's
294,
constitution. Party's constitution. Okay, so that is why.
yes,
Yes.
the 293 was not clear.
And 21, 22, 23. Okay, he overstayed 2 years. So what the constitution says, if he overstays or no election is being conducted after the expiry of the tenure.
The chairman will remain, but then they will have to go for election.
Rest.
Yes, the election will have to be held, and therefore, my lord, they went for election.
But the tenure of the chairman is also for 3 years.
3 years.
They are elected along with the other executive body.
Yes, yes.
On the same year.
You're right, right.
So, but then this other executive body, it expired 2021.
21, but then the election was there, the election was held, and they were again appointed. Now, in the meantime, my lord, they filed a case saying that, my lord, they cannot hold the office because the returning officer was appointed not by because the chairman has no power to appoint the returning officer.
According to them.
According to them, it has to be done by the president.
No, the decision taken to do away with the post of the chairman was only after expiry of the tenure of the chairman only.
Right. That's right, after the expiry. But the question would be whether it was done in accordance with the law.
It has to be.
It has to be by any means.
Right.
Because if we are to look at 29 Constitution, Article 29, Article 13, Article 36, everywhere they say.
Is there any provision provided under the Constitution that what happens after the expiry if the election is not conducted? You say that election will be conducted by the chair. How the chairman will remain, because the chairman's tenure also expired.
Yes,
2021.
Even that ordinarily, my lord, what happens so far our bar council is concerned.
Yeah.
Now, when the term expires, they continue to remain in the post. There will be information from the Bar Council Delhi how to deal it in appropriate manner. They will give a time within this time election to be held. Because otherwise, my lord, the post cannot remain vacant. Because the functionary, they will have to do their work.
This is then in respect of all the executive
And
body,
election
including
is-
chairman.
Is in respect of in all the elected body, it is like this.
Okay.
Because in our bar association also, when the term expires, if the election is not held, they continue to be president
to hold the
and
post.
secretary.
Okay.
Otherwise, my lord, that post cannot be kept vacant because the work will have to be done.
Now the decision to do away with is after their election or before?
No, it is after the term is over.
After the term is over.
Yes.
It was the decision at the instance of the president secretary of.
It was, my
That
lord, it was like a drama.
Okay.
On 4/10/2022, they are saying that election, if the executive committee held an election. Now, if you want to amend certain part of the constitution, people's mandate is a must.
Right.
Now,
It has to be initiated by the president or the chairman?
by the chairman.
Chairman only.
Yes.
So here in the present case, chairman has never initiated anything. that
Chairman was not in the picture at all.
Okay.
So if it is not done by the chairman, how the constitution can be amended by the
Right,
president?
because the president who has initiated,
Yes.
his tenure also over by 21.
No, yes, his tenure also over.
Ah.
But he pretended
Hmm.
that the election was held on 4/10/2022.
Okay.
And therefore, by virtue of that election, it was unopposed.
Ah.
And I became the president and the others became secretary general like that.
Now thereafter only they took steps.
Yes,
to do
yes.
away with the chairman.
Thereafter,
The post of the
yes.
chairman.
Right. And now your lordship has seen the drafting committee members out of 4, I think 3, no? 3 of them said, this is not an amendment. This is illegally done. So we are not consenting to that. Now, I have read it, your lordship has seen. Now, even, my lord, even they don't give their consent or not, it's a different issue. Question is whether the amendment is done legally or not. That is the whole sole question
Now,
to be
the
answered.
drafting committee, if they doesn't come or didn't come into some conclusion, then how that will be effective? The decision to do away with all those also.
Drafting committee is not supporting them. Drafting committee.
Then how did it come into, this decision came into?
Decision?
Unless the drafting committee agree with, or drafting committee submit their draft.
Drafting committee is saying that we are not agreeing to this proposal.
Okay, then who finalized it?
My lord, they themselves, president, secretary general, they themselves made it final.
Okay.
These only the 2 persons. And by doing that,
imposing it to all other.
Yes, yes. And by doing that, what happened? They filed this suit saying that their first prayer is that declaration of their title. When you want declaration of your title, then it is your duty to prove the case. Now, did you prove your case? What happened, my lord? It is quite reverse way. They are saying defendant did not held the election in terms of the statute, I mean constitution, where chairman cannot appoint a returning officer. Only the president can appoint a returning officer. Because of that fault, this election to be stayed, because this election is not legally held. This is the defendant's case. You have to prove your case first, because the plaintiff will have to stand on his own legs. You must prove your case that you were elected on 4/10/2022 through complying the constitutional provisions like Article 29, Article 13, Article 36. Now, it is not their abandonment in the plate, nor it is the case also. Now, the entire thing falls in that way. When you could not prove your case, how you are entitled to get an injunction order?
The title suit is filed by
the plaintiff, respondent number 1 and 2. Now,
but by the time they filed this suit, title suit, they were already elected, they have already been elected
That is the main.
according to them.
That according to them.
Hmm.
But could they prove that election was held legally? That's why question of Article 29 comes. Because whatever you do, your election will have to be approved by the chairman.
Okay, so that means the title suit filed against the chairman and the president also. Who else are with the
No,
party?
against the, my lord, I'll take your lordship to that. Your lordship kindly see page 74, my lord, this is the plaint.
Is this the party that the president and the secretary who filed the title suit? Is that the total new team other than the existing?
Yes, it's new team.
Total new team.
New team. New
They,
team.
this president and secretary who filed title suit were not in the earlier executive body.
No, no.
Okay.
It is
This
completely-
Kappa Bengia.
Against they, after our election, they conducted another election. We filed case against the suit against.
No, that is why I wanted to come. So that means,
Against the new team.
so there were two
Yes,
team.
Yes.
Okay, parallel,
Yes.
holding the post
Yes.
of the president.
Yes.
There were double team, two
Yes.
teams.
Yes.
Yes, yes.
Okay.
Two people.
Okay.
Because after we conducted the election, they also conducted another election.
Okay.
So we
Who
challenged
conduct the election first?
the chairman.
The chi-
First
No,
we
no,
conducted.
first they.
First we conducted.
Okay.
Then when we were elected, the chairman.
And when they conducted election,
We
so
challenged it.
you challenged them. That you are the first one, you are existing one. Okay. So when you conduct election, so you follow the issuance of the notice also 1 month.
Yes, yes.
Okay, you followed all those.
Right. And they haven't said all these things in their plaint that we haven't followed. Those statements are not there at all. So therefore, we are concerned with their case, my lord. Now, if I take your lordships to other papers, how? Okay, now, my lord, please keep my 273. No? Your lordship kindly see another.
Now presently the status, who is occupying the office? Both.
No, we are not, because of the interim order, we can't
Okay,
do anything.
Sorry,
Because we have been restrained.
they are functioning now.
They are functioning.
Okay. So they are functioning without chairman. And
Without
according
chairman.
to you, yeah, the chairman is also still, according to you and
I
your
am the chairman of this authority.
chairman.
Only
So there is
because-
also president and secretary also in your.
Yes, yes. Only because of the interim order, we are not in a position to do our functions.
Okay.
Once this is lifted, we shall be in. And your lordship see the result. My lord, I am drawing your lordship's attention another interesting thing at page 273. Declaration result on 14th October 2000. 4th October होगा ना? Page 273, my lord. PPA organization election 12-14th October 2022.
Yes.
Your lordship will find down below, extreme left hand side, Taba Tagar returning officer. Your lordship kindly see the signature. And then, my lord, for a file at page 287. Page 287, your lordship will find Taba Tagar, the down below, my lord.
287A.
287. Not a, my lord, 287 only.
Yes, it's different.
Your lordship will find Taba Tagar signature.
Yes, different.
Then again, your lordship kindly see 273.
No.
Again, 273 signature of Taba Tagar.
73.
Yes.
Taba?
Taba Tagar signature.
Yes, same, I have seen.
This is the forged one, and the original signature is page 287.
Okay.
This is the signature of Mr. Taba Tagar. Now, these are very relevant in the sense there was no election on that date, and the returning officer.
So, Taba Tagar denied this organization election.
My lord,
having signed in this organization election.
yes,
14.
it is his signature have been fraudulently made. It is not
Hmm.
his signature.
No, not the signature, but whether this Tawa Tagar who signed in 287 denied
Now that
denied
occasion,
his signature
Well,
having
this-
signed in the page 273.
my lord, this occasion did not come at all because there was no evidence taking.
Hmm.
My lord, the trial
No.
court, what they did, my lord, just after
The
seeing,
Tawa Tagar is in your team or in their team?
he is an independent member, my lord.
Independent
He has said this is his original signature
So
and this
so
is a fraudulently.
if this 273 is a forged signature of
Yes.
Tawa Tagar, whether he lodged any FIR anyway?
Yes, yes, FIR has been lodged.
FIR lodged.
FIR has been lodged. It is
Okay.
pending.
Okay.
It is, we
Investigation
have
still
annexed that
pen-
FIR.
Investigation still pending.
Yes, yes.
Okay.
And then page 273, Your
270.
Lordship kindly say Lagum Tagya.
Yes.
He is a non-member.
Hmm?
On that date, he was not a member. He was inducted later on. You know, these are all these things.
Not a
ought to have
member
been-
means
Your Lordship at page 273.
Lagum Tagia.
Lagum
Lagum
Tagia.
Tagia, yes.
Now, he was on that particular date, he was not a member of the organization,
Or not a member.
not a member.
But
He
then
was,
he signed as assistant returning officer.
yes, he was inducted later on, my lord. I am
Okay.
just handing over. He was inducted on 2/2/2023.
This is the election of the respondent group.
Yes, yes. 4/10/2022 election.
1410. What is this?
This is,
India.
he was this gentleman, Logum Tagia. He was appointed as a member on 2/2/2023.
Okay, before he was
Before he was a member, he was shown
member,
as
he
a
was already assistant returning officer.
assistant returning officer.
This is, of course, this involves with the
Now, these are the things, my lord. One has,
dispute of fact. Of
yes,
course.
exactly that. my
Huh.
lord. Acute, my lord, dispute.
Open my mouth.
Yes.
No,
Okay.
appropriate
Right.
time you will open.
Yes, that's fine.
Okay.
My lord, so these are the questions what I am saying. This is the learned judge ought to have been taken evidence and could have come to the proper, my lord, finding. Now, when I read the finding of the learned judge, your lordship will be astonished to see is a peculiar finding without going into the merit of the case. And there was no occasion because the plaintiff also they did not say anything. Whether there was a people assembly, there was nothing at all.
Have you annexed this order also?
No, this recently we have collected it.
Okay.
These are the things, my lord, trial court will have to make a scrutiny after taking evidence. Let's now go to the order first. Now, my lord, I'll trouble your lordship little bit. The interim injunction passed, which your lordship will find it. Which is mine? 166, no?
Probably you may have to file, if you want this document to be taken, you may have to file additional affidavit.
For the time being, my lord, although I'm placing before your lordship to see how the things happened.
Yes, yes.
Now, if it is sent back to the trial court, it's a matter of trial court to take evidence of all these people.
Yes.
Now, I'll take your lordships to the order passed by the trial court on 22/12/2023 at page 166. whether your lordship can extend the time
Yeah, there is a four
up to 5.
Still we have.
At page 166, 166 is the trial court's order.
Yes.
The instant miscellaneous application has arisen out of title suit number so and so. The application has been filed by the petitioner plaintiff under order 39 rule 1.
Is this the impugn order?
This is the first order passed by the trial court.
First order.
Yes.
This is not.
This is not the impugn order.
Okay.
But then, since this is the first order I'm taking to
Okay.
your lordship
Yes,
here.
please. The instant.
Then your lordship may start from the case of the petitioner.
Okay.
The case of the petitioner plaintiff is that the plaintiff number 1 is the president of PPA and plaintiff number 2 is the secretary general as per election held and result declared on 14/10/2022. The defendant number 2 was the chairman of Central Working Committee. That means I was the chairman. However, on 24/9/2022, the executive members of PPA, your lordship kindly mark the language, executive members of PPA convened a meeting that should have been convened by the People Assembly. And resolution was passed to remove the post of chairman by 4th Amendment on 4/11/2022. Thereafter, the defendant number 2 ceased to be the chairman of the Central Working Committee. That white letter dated 14/10/2022, the president of PPA submitted the updated list of office bearers to the Election Commission of India, New Delhi. However, the Election Commission of India white letter dated so and so informed that the details submitted are not in prescribed format. Now, your lordship may skip up to the middle part, your lordship may come. Learned counsel, Mr. So and so from there. Learned counsel from so and so appearing for the petitioner plaintiff submitted that as per Article 14 of the Constitution of PPA as amended on 4th November 2022 provides for PPA Central Working Committee. As per Article 14(1), the president of the party shall be the chairman of the PPA CWC. Therefore, there is no separate post of chairman CWC. The defendant number 2 illegally issued circular dated 4/11/2023 and defendant number 1 illegally conducted election and declared result dated 12/11/2023. Therefore, the election result dated 12/11/2023 is illegal and liable to be quashed, and in the interim, the defendants be restrained from terming themselves as the People's Party of Arunachal Pradesh. It is prayed that temporary injunction may be granted ex parte and interim, as the object of granting the injunction would be defeated by the delay in service. The notice of application to the opposite party is dependent. Peruse the plain miscellaneous application and the copies of the documents. On perusal of records and hearing, it is seen that the present case has been filed seeking for decree in favor of the plaintiff for declaration of title in their favor, and a decree declaring the election result dated so and so as illegal, and permanent injunction under section 38 of the Specific Relief Act. I have gone through the letter dated 18/9/2023 under Secretary of the Election Commission of India to the President of PPA, wherein it is stated that in regards with the updated list of office bearers furnished by your letter dated so and so, it is informed that the details submitted are not in prescribed format. Therefore, it is advised to furnish the organizational election details of the party along with a complete list of office bearers, members of the committees, etc., elected at such elections in the enclosed format. In the said letter, the Election Commission has not stated that the tenure of the present office bearers expired on so and so. I have also gone through the constitution of the PPA. As per Article 12(2), the president shall be elected for a period of 3 years, which implies that the tenure of plaintiff number 1 will be till 14/10/2025, as the election result was declared on 14/10/2022. The election result has not been challenged. Further, Article 14 of the Constitution of PPA as amended on 4th November 2022 provides for PPA Central Working Committee As per Article 14(1), the president of the party shall be the chairman of the PPA-CWC, which implies that plaintiff number 1 is the chairman of CWC. Further, as per Article 38(1) of the president, in consultation with the state executive, shall appoint a returning officer for conducting election of the party, which further implies that it is the plaintiff number 1 who is empowered to appoint the returning officer. In the instant case, the defendant number 1 returning officer was appointed by defendant number 2. The petitioners plaintiffs have a good case to go for the trial and having their claims adjudicated upon. It is the party who would suffer greater loss would be said to be having balance of convenience in his favor if the election result of the defendant dated 12/11/2023 by OP defendant number 1 is allowed to remain in effect. The hardship or inconvenience caused to the petitioner plaintiff will be much greater than which is likely to be caused to the opposite party. The state general elections are approaching and the political party is actively functioning. If the defendant 2 to 22 are allowed to function as state executives of PPA parallel to the plaintiffs, the comparative mischief, hardship or inconvenience which is likely to be caused to the petitioners by refusing the injunction is greater than which is likely to be caused to the opposite parties. The same is not granted. Therefore, the balance of convenience lies in favor of the petition. Further, an irreparable loss must be one of a kind which cannot be adequately compensated by damages. An injury will be regarded as irreparable where there exists no certain pecuniary standards for measuring the damage. In the instant case, if the election result dated so-and-so is allowed to remain in force, then it will be difficult to bring back the party status to the present state. The damage caused to the petitioner plaintiffs would be such that it will not be possible to be compensated if the case turns out in favor of the petitioner's plaintiff. Further, the petitioner's plaintiff has satisfied this court that the object of granting the injunction would be defeated by delay in serving notice to the opposite party, considering the fact that if notice is to be issued and in the meantime the opposite parties might end up making major party decision and alter the position of the party. Accordingly, the election result of the defendant number 2 to 22 dated so-and-so declared by defendant number 1 Sri Lokhi Boje is hereby stayed until further orders. Further, the defendants 2 to 22 are restrained from functioning as state executive PPA and further
This is the election of the petitioner, right?
Yes.
Okay.
Yes. This 2012/11/2023, it was our petition.
Okay.
Further, the defendants 2 to 22 are restrained from functioning as a state executive PPA and further directed to refrain from using the emblem, stamp and letter pad of People's Party of Arunachal until further orders. Issue notice. Now, this order we have challenged by the vacation application. The order was passed on that on 4/3/2024 at page 57. We file an application to vacate that order.
Yes,
under Order 39, Rule 4.
This is first order.
No,
this
this
is
is
earlier one,
my lord,
22/12.
The first order is 22/12/2023. Just I have read. Now, this was passed ex parte.
This 22/12/2023 is ex parte.
It is ex parte without issuing notice, my lord, that order was passed.
Okay.
And as the lordship has seen, there was no satisfaction expressed by the learned judge coming to that conclusion.
Right.
Whether there was a, my lord, People's Assembly was there or not, whether one notice was given for the People's Assembly to be held. Everything, my lord, in a hush-hush manner it was done. There is no reflection of those things. So therefore, this ex parte order, as he wished, he has passed it. There was no satisfaction. He did not go through the plaint. He did not go through the party's constitution, and he has passed an order. Now we filed an application to vacate under Order 39, Rule 4. And my lord, I wanted to read that application also, but it will take a lot of time.
Okay.
So I'm not
No.
reading it.
No.
The order
Where is
passed.
the application?
Yes. Application, yes. That application, your lordship will find at page.
This order 22/12/23 was passed in which application?
This is
Application filed by the president and secretary.
application.
Hmm?
My lord, miscellaneous 1 of 2024.
Page
140. Page 145, my lord. Just 145, no?
just a minute. Huh?
It is their petition. 145 is their petition, my lord. And then our petition is
Just a minute. Huh?
this one, no?
So this
Vacating
is
application.
39.
Our application is one at page 170, your lordship will find.
Okay.
Application under order 39 rule 4.
This was the 145 is first application filed by the respondent.
Plaintiff.
Plaintiff. No?
Plaintiff respondent.
Okay, this was the first application.
Yes.
And then 166 is an order dated 22/12 is the first order. Okay, your application is at
Our application is at page 170.
117.
170
170.
to vacate that order. We have specifically given our reason why that order is required to be vacated. Along with that, we filed our WS also clarifying all the loopholes of the
This was 170 was filed application for vacation.
for vacation. At page 170, your lordship will find application and order 39 rule 4. For recalling the order dated 22/12/2023.
Okay, so that was in title. Miscellaneous number 1. Miscellaneous case number 113. 113. Okay.
Now there
This just a minute. This interim order was passed in title suit number 10. And
yes,
then-
yes.
And this was named okay.
Then in our petition, your lordship may mark the paragraphs, the point taken by us at page 179 in paragraph 6. Paragraph 6.
Paragraph 6. Yes, what is that?
At the very outset, the applicant begs to state that the respondents have misguided this honorable court by placing reliance on a non-existent Fourth Amendment of the Constitution of PP. The respondent, who are the plaintiffs in title suit number so-and-so, miscellaneous 113 of 2023, have made submission in their claims that the applicant number 1 was the chairman of the Central Working Committee. However, on 24/9/2022, the executive members of the PPA convened a meeting and a resolution was passed to remove the post of chairman by Fourth Amendment on 4/11/2022, and hence the applicant number 1 ceased to be the chairman of the Central Working Committee. It is pertinent to mention herein that the submission of the respondent as well as their annexures are silent with regard to the conduct of People's Assembly, which is the only way through which any amendment of the Constitution of the PPA can be done. Article 29 lays down the provision with regard to amendment and states that the party constitution shall be amended only by the People's Assembly. The notice or proposals for amending the Constitution shall be given 1 month before the said assembly. Now, this is the vital point we have taken there, but it was, my lord, did not give any credence by the learned judge. Then my lord, at page 181, paragraph 7. That the 181, paragraph 7.
Yes.
That the applicants beg to state that according to the Fourth Amendment of the Constitution of PPA submitted by the respondent in their prints in title suit number so and so, the drafting committee includes 4 members, including the respondent number 2, Sri Kaling Jarang, that all other 3 members of the drafting committee, Sri Rigam Santana, Sri Marli Kamki, and Sri Tai Tadap, have raised objection with regard to the Fourth Amendment of the PPA Constitution and have submitted in their letters to applicant number 1 that no People's Assembly has been conducted till date for amending the Constitution, and no such resolution was passed to remove the post of chairman of CWC as claimed by the respondent hearing. And the Fourth Amendment is illegal and cannot be upheld in law. Then para 8. These are very vital paragraphs and ignored by the learned trial judge. Para 8, that the applicants beg to state that the applicant number 1 is still the acting and existing chairman of Central Working Committee, as the Fourth Amendment of the Constitution of PPA is untenable in the eyes of law. That being the case, the applicant number 1, being the chairman of CWC, is hence empowered to take actions for the interest of the party, as the chairman CWC is the approving authority for all important decision of the party under Article 13(4) of the Constitution of PPA. Article 13 of the Constitution of PPA provides that the PPA Central Working Committee is the highest decision-making body of the People's Party of Arunachal. The PPA Central Working Committee shall consist of the chairman of the PPA State Council. Now, these are the things your lordship has seen earlier also. Then I am skipping from there. Then,
So this in 8,
8, my lord,
para 8, what you want to here?
is the provision of Article 13 have been elaborated. Then 9, your lordship may skip. Then para 10. There is the contention of the plaintiff in title suit number so and so that after the above.
Just a minute.
Yes.
So this application, because there was, you said that there was only 4 drafting members.
Yes. Out of 4, 3 objected.
What is the procedure for selecting the drafting members? It is in the meeting of the.
It is the executive committee meeting was there.
Okay.
And they tried to change that. Then 3 members found that this is illegal. The executive committee cannot hold all these things, because if you want to amend the constitution, it will have to be through People's Assembly.
Okay.
Now, elected body has no, executive committee has no power to do that. Therefore, they objected to that. That election.
Then I think today it will not be able to complete.
That also I realized.
Yes.
Not even half.
So I think that we may have to post it. Any day.
Is it possible tomorrow, Mali?
Tomorrow list already prepared. After tomorrow, so that it comes in the list, because if because list already prepared, considering that how much matter can be taken out.
After vacation. After vacation.
Only problem is this, your lordship has seen, is a very hefty matter. If I wait for so many days again, I'll have to read it. And it's a great headache, because factual matters are there.
Right.
The lordship understand to.
That is there.
Then suggest SL when lordship is here, matter can make it so that your lordship did not hear, otherwise it will be if another.
We can do one thing.
Next week, any day.
Next week, your lordship will be there.
Yes.
Will it be convenient to next Monday, Mali?
Next Monday.
24th क्या Monday है? Monday.
Since this is, okay, this will take time, so what we can
Yes,
do
yes.
is we can just keep a little lesser item so that this can be hard. That way it can be.
Friday, will it be possible? Friday.
No,
This coming Friday?
Friday, I'm already would be.
Okay, Monday.
Monday,
Yes, no, I will definitely cooperate from my side.
Monday.
No, he's cooperating always. I'm really obliged.
Yes, he is cooperating. Monday.
Monday, my lord, if the list is small, then it is better for us.
Okay. Who will instruct?
Can it be on the top of the list?
Among the, yes. Okay. Mr. S. Datta, Lana Senior Counsel, Senior Advocate, assisted by Ms. T. Y. Bhatia, Lana Counsel for the petitioner. Staff. Also had Mr. P. Kapo, Lana Counsel for the respondent number 1 and 2.
Yes.
And who else?
5, 7, and 2, 23.
You are Miss
A. Rai.
A.
A. Rai.
Rai, Land Council for the respondent number 3, 4, 5,
7
and
7 to 23.
7 to 23.
Yes.
I'm afraid notice has to go to 6 also, I don't.
Who is 6?
Otherwise, all our arguments will be in futility.
I hope the steps for the service completed.
Service complete, yes.
6 is not appearing.
6.
Who is 6?
6 Kune.
Be rejoined.
Who is? He is.
Yes.
6
Service will complete again, but there will be difficulty.
No, we shall see to that, my lord. If anybody is there, then if you can appear, it's all.
This is already completed. Also filed our affidavit also with regard to that.
6
So this is
also.
already completed.
6 also.
Yes, I think.
Then it's all right.
It is fine. If you have left. Here, if you
Six probably has not reflected in the office note also, probably. Just a minute, 3, 2. But 6 never appeared in the pair. Respondent number 6 never appeared. It was Dusty service.
Dusty था क्या? उसमें है.
Who is this 6? He is also the member of the. You are not representing. Where is the one? Who represents the all other? You are not representing 6.
We have not reflected 6.
6 also you are representing?
No, no.
No. Six is not represented by them. You need to check probably.
Service was completed upon him. I'll update on that on the next page.
It's okay, Malay. If service is completed, we have no.
Okay.
It's been complete, है ना?
His raised for and then agreed upon by the land council for the parties. This matter again on 24. Hmm? What? No.
No, Bakri.
22nd.
No, cancel it. I didn't help us.
24. 24.
When you come back to indicate.
Okay.
25th. My lord, 25th will be here. 24th, my lord, she will not be here.
Okay.
So
Then
can I request for 25th?
25th. Okay. 25th. Hmm.
Item number 16.
15 over. No one appears. Okay, no one appears on behalf of the parties. on court.
For the state, your lordship.
Okay, okay. Appears on behalf of the petitioner. You are for?
Gum,
This is
PP is off.
16?
16. Oh, no, your lordship.
No, no, 16
Different.
probably you're not. Okay, no one appears for the parties on court. Case is then adjourned. List the matter after 3 weeks.
Item number 17.
Same order. Appearing?
Yes.
Okay. You are for petitioner?
Yes, lordship. I'm for the respondents, my lord. So we will need around 2 weeks time to file a counter affidavit.
Okay. Mr.
T. Darren, on
Direct
behalf
counsel
of
for the
the
petitioner is
Magenta.
present. Mr. Peter for direct counsel for the respondent, prays for further 2 week time to file counter affidavit.
Lordship, there is an interim order. Earlier interim.
Except 17. My lord, except 7 and 17, we are representing rest of the 7 and 17, we are not representing.
7 and
17.
17.
Yes.
Except 7 and 17?
Yes, rest.
Okay. Now, counsel for the petitioner, no, sorry, respondent. Number. The respondents except 7 and 17.
Yes, my respondent 1 to 31, except 7 and 17.
Okay. Prays for further 2 weeks time. 2
Yes,
weeks time.
yeah, 2 weeks time.
To file affidavit in opposition.
Yes.
Okay. So no one appears on behalf of the respondent number 7 and 17.
No, they have not.
Okay. That is great. So, list is matter after 2 weeks.
Yes.
Lordship, there is an interim order.
Okay. Para. The interim order passed earlier shall continue till the next day.
All right.
Item number 18.
It is also there. Okay.
Lordship, in this
And
matter,
then this matter, I think is already fixed earlier. Fixed.
no, 18,
18.
yes, 18, the service has not been completed yet.
Okay. You are for
And for the state, your lordship.
18 for a state, okay. No one appears on behalf of the petitioner on court staff. Miss Jeannie Leonard, additional TP, is present. The office note dated 15/6/2024 reflect that the notice upon the respondent number 48 is still awaited in view of the above. List this matter after 2 weeks.
2 weeks.